to move an unlisted matter. Today, my lord, sorry.
What is the urgency?
Urgency, my lord, the petitioner has been transferred, my lord. He has only 64 days left, my lord, in service. He is going to retire in 34, my lord. And there is no public interest, my lord, on why he has been.
Are you sure there's urgency involved?
My lord,
Okay.
today, my lord. 2, my lord.
My lord, this matter pertains to compensate appointment, my lord.
Hmm.
After due service to all respondents, the matter has not been listed, my lord. My prayer was listed on 6/3, my lord.
6 will be difficult. We'll have it on 11.
For others, my lord.
Okay.
I would like to mention three recruitment losses for listing admission column. It was listed in the year 2003. The 20 March also.
13 March.
13 March.
May I please, my lord? I like to mention item number 14, my lord, with the consent of the petitioner, my lord.
Item?
14, my lord. Sometime maybe granted need to file affidavit, my lord.
There is an interim order, my lord, that may be continued. I've heard a petition.
Okay, you are Mr. A.T. Chowdhury.
T. Chakraborty.
Heard Mr. T. Chakraborty, Lena Council for Petitioner, on request made by
P das, my lord. Respondent number
Das.
226, my lord.
Standing Council,
Well, sir.
ABDCL. How much time?
3 weeks, my lord.
3 weeks time is allowed to file contract. List of it.
May
Interim order,
Yeah.
interim order pass earlier to continue till the next agenda.
Obliged.
I give your lord, my lord, this matter relates to the family pension, my lord. Pension matter may be listed on 4th March, my lord.
What is difficult? We'll have on 13 March.
May I please? With the consent of the other party, my lord, I beg to mention item number 18, my lord.
Yes,
And the agenda matter 4.
you have 4?
I am for the respondent number 5 here. I have taken consent from the petitioner.
Okay, on request made by Mr.
A Boromet.
A. Boro, General Counsel for Respondent number 5, list the matter after
After a week, my lord.
1 week.
Obliged.
May I please, Your Lordship? I would like to mention item number 37, Lordship. For the consent of other side, maybe pass over for the day, Lordship.
On request made by H. Alamgir and the Council for the Petitioner, list after 2 weeks. Yes.
Item number 29, my lord. In this case, respondent has filed their affidavit.
Hmm.
We need to file reply, man. So 2 weeks time may be granted.
You are Mr.
N.K. Kolita, my lord.
On request made by N.K. Kalita and the Council for Petitioner, 2 weeks time is allowed to file reply to the counter filed by the respondents. List
All right.
after 2 weeks.
May I please, your lordship.
Hmm.
Lordship, I will beg to mention item number 34, your lordship.
Hmm.
I have taken consent from the other side,
Hmm.
BTC.
Hmm.
The matter will come after 2 weeks, your lordship.
Your good name?
I have made
35.
34, your lordship.
34. On request made by I have and the Council for the Petitioner, list the matter after
2 weeks, your lordship.
2 weeks.
So there is an interim where it may be continued.
Interim order pass earlier.
Keep the pledge.
May I please, Lords? My lord, IA for correction, Lordship. Main list is going to be listed day after tomorrow, Lordship. May I pray for my lord listing the matter, IA, my lord, for correction along with the matter.
When is it listed?
Tomorrow, day after tomorrow, Lordship.
Your writ petition.
Yes, Lordship. Obliged, Lordship.
May I please, your lordship? Lordship, I beg to mention a matter for listing, lordship. Matter is of 2023, lordship, next week, if possible, lordship.
Next week's little. We'll have it on 14th.
Much obliged. May I please, your lordship? Lordship, I pray for listing of an item. The matter was last posted on 20/11/2023. Can it be posted on Wednesday, lordship?
No. Wednesday is difficult. We'll have it on 15th March.
15 March. Lordship, there is another matter which I pray for listing that came for admission hearing. And it was last listed on 27/6/2023,
Okay, same day.
15 March. Obliged.
Lordship, I beg to mention for listing this to writ petition for motion, your lordship, if possible tomorrow, your lordship.
Why?
Actually, contractual employee, your lordship, terminated from service without following the, without giving the opportunity of hearing, your lordship.
New method,
New matter, your lordship.
Friday,
On Wednesday, your lordship.
Friday, first.
Obliged.
May I please, your lordship? I'd like to mention for listing of an WPC matter is lordship, and matter has become infructuous. To come up for orders on Wednesday,
When do you want?
Wednesday
Okay.
of like.
May I please lordship, I beg to mention for listing lordship, for hearing. Next to lordship,
Hearing,
hearing for
12,
lordship. Another, I have lordship for admission lordship.
14,
May I please your lordship, lordship, I beg to mention item 31 and 32. May it please be adjourned for the day.
31 and 32.
Yes, your lordship.
Your good name, please.
Miss M Glory,
M.
Glory.
Glory, on request made by Miss M. Glory. Legal counsel for the petitioner. When do you want?
Lordship, after a week.
After 2 weeks.
Please, lordship.
May I please to lordship? Item number 2, lordship. Matter may be come up next week.
Why?
Yeah, we have to file additional.
Let it reach. Let it reach. You wait. Wait for some time.
Item 1 of daily list, motion.
May I please your lordship. My lord, this is a contempt petition which is arisen due to non-compliance of order dated 3/5/2023, my lord, passed in WBC 2250 of 2023, my lord. My lord, the directive portion is at page number 12, my lord.
Page number?
Page number 12, my lord.
Have you served a copy?
Yes, my lord. The acknowledgement is at page number 13, my lord.
Heard, Mr.
PH core, my lord.
PH Kunwal legal counsel for petitioner issue notice. Petitioner takes steps for service of notice on the sole respondent
Yes, my lord.
by registered for TD within 1 week, please up to 4 weeks.
My lord, the name of D. Hussein may also be recorded, my lord. He is also the petitioner.
Hmm?
My lord, his name is not reflected in the causes, my lord, but he is a party, my lord.
Who?
My lord, B. Hussein, my lord.
Registry is also directed to reflect the name of Mr. B. Hussain and as the legal counsel. for the petition.
B. privilege, my lord.
So,
Yes, what do you want?
Lordship, matter may be come up next week.
Next week. Why?
We have to file additional.
Okay. On request made on behalf of M. Bahawir and counsel for petitioner, list the matter after 1 week.
3,
Outline.
May I please, your lordship? My lord, the petitioners before your lordship is, my lord, the MR level of my lord who have joined my lord prior in the year 1992, my lord. My lord will file the list of their engagement at page 20, my lord.
Yeah.
Thereafter, my lord, there has been the certificate issued by the concerned authorities that they have been, my lord, in service 1992. So, my lord, my limited prior hearing is that, my lord, in the irritable, my lord, 45. My lord, in 2014, my lord, the government of Assam had adopted policy, my lord. They have considered, my lord, those, my lord, persons who have, my lord, more than rendered, my lord, continuous service of 10 years. That they have been, my lord, formulated policy to pay some fixed, my lord, pay and some, the minimum wages and some medical benefit. Considering that aspect, only, my lord, my humble prayer is that, my lord, our my lord, claim should be verified and their, my lord, thereafter the claim may be considered, my lord, in pursuance to the order passed in the reappeal, my lord.
Let
notice flow. Notice. Let notice flow.
Heard, Mr.
BK Das, madam.
We get our legal counsel for petitioner issue notice.
I for 1 and 2, Lord.
N Upadhyay for 1 and 2. 1 and 2. Lot. Mr. N Upadhyay, Learned Standing Council, Irrigation. Appeals for respondents 1 and 2.
I will say for 3 and 4.
And Mr.
As Bora for 3 and 4.
S. Bora, Learned Standing Council, BTAD,
BTC, man.
BTC. Appeals for respondents 3 and 4. Notice and respondents are complete. However, extra copies you furnish. Respondents are allowed to file affidavit. List after 4 weeks.
Like 4.
David, Disciplinary regarding a selection and appointment for the post of Gavura. Advertisement made Millard, I am, and as per advertisement, I am not qualified, so I applied for the post Millard. Interview was there, but I was not selected. Though Millard, I am the son of Gavura Millard. And there is a Millard, on the advertisement, it is mentioned that the son of the Gavura or family members of the Gavura will be Millard, will be given preference. But that condition is not considered. So
Where is your certificate?
my certificate Millard, son of Gavura, you may kindly see, page Millard 21. There is a particular translated copy. It is even another Mujada written. Son of Mujibur Rahman ex Gavura of village Swansu Swansu.
Where is the advertisement?
Advertisement kindly see annexure 1 minute page 11. And page 12 minute 11%. Column 9 12 minute. Page 12 from the last minute. Family of ex Gavura will be given preference and recommendation of Mojadar will be considered. And Mojadar recommendation is also there, Milord.
That is only preference.
Preference.
Only preference.
When 2 persons are equally situated, then the preference will count.
Even in Lordship, there is a appeal provision.
Yeah, what that 123 or whatever.
Lordship, last Friday I was given my lord.
Where is that?
There is a appeal live for the Milord Lawyership Commission, but I have
No,
filed earlier some commission Milord to appeal, but those appeals are pending till date, no order passed Milord. Then we just send Milord a dispute. And also there is no sign, no hearing Milord, nothing. So Milord, I have mentioned in petition appeal petition Milord, nothing is there Milord.
Where's the appeal?
And I have not mentioned in this case appeal. Another case I filed, they are not hearing him.
In this case, you have not appealed, isn't
No,
it?
no, I have not filed
Then
appeal.
why are you saying you appealed?
Now, another case I filed, they are not hearing it. So, I am before Lordship.
The appellate board was constituted on my lord 1/2/2024.
1/2/24.
Where is that?
Lordship, that circular, my lord, I forgot my lord. I will give them my lord the number.
But I require that now, no?
Lord,
To dispose of this matter.
Lordship, my lord, I will give it. I'm sending this matter.
Get a printer.
Huh? 98642.
And it's 67, 5. What's it? What's there? Go ahead.
As per advertising, there are some conditions. Those all conditions are with me, Milord. I am son of Gavura, Milord. I have land, Milord. I have, as per there should be more, not more than 2 child. There is also a complaint, Milord.
Where is your certificate? That certificate?
Annexer, Milord, son of Gavura, page 21, Milord.
Page 51.
Translated Bhanigalar is there, Milord. It is certified by Matiur Rahman. I am the petitioner of the Lordship. Son of Mujibur Rahman, ex Gavura of village Swansu Milord. He has applied for the post of Gavura. I know his character is good. If he is appointed in the said post, he is supposed to discharge his duty.
What's this? You make one more copy and keep it here. Okay, heard Mr. A. Roshik, other counsel for the petitioner. Also heard Mr. J. Hentik,
For respondent one lot.
Leonard's government advocate,
Lordship, SC revenue lot.
understanding counsel, revenue department for the respond number one. And Mr.
Jackie Parajali.
A.K. Barajali, and government advocate for respondents,
2, 3, 4 and 5.
2, 3, 4, and 5. Stop. Para. Is it a notice or an advertisement?
In my appeal, advertisement, my lord. Next are only advertisement.
Pursuant to an advertisement dated 26/5/2022, wherein applications were invited for 101 vacant posts of Gaon Pradhan under revenue circles of district Nalbari. The petitioner, who claims to be the son of an ex-comber, applied for the post. Stop. In the said advertisement, clause 12 provides that family of ex-Gambara will be given preference and recommendation of Mauzadar will be considered. Stop. The Mauzadar Bangaon accordingly issued a certificate to the petitioner stating that he is the son of an ex-Gambara of village Simalia, Mauza Pakua Circle, Pashinal. Stop. Grievance of the petitioner is that he has not been selected. Grievance of the petitioner in the following petition is that he has not been selected for the post of Gaon Pradhan. Stop. Para. Mr. J. Hendrik Leonard, Standing Counsel, Revenue Department, submits that the Revenue and Disaster Management, within bracket LA and A Department, has issued a notification dated
1/2/2024.
Wherein amending what? Executive Instruction number 162
C lot.
C of the Executive Instructions under the Assam Land Revenue Regulations, 1886, within bracket amendment 2024. Stop. He submits that under the Executive Instructions 162 C, an appeal against the order of appointment, suspension and dismissal of a Gaon Pradhan by the district commissioner or by the principal secretary of the autonomous council area shall lie to the director of land records and service Assam within a period of 60 days from the date of receipt of a copy of the order of appointment, suspension, or dismissal, as the case may be. Stop. Para. After hearing the contact with the parties, this writ petition is disposed of, directing the petitioner to file an appeal before the Director of Land Records and Service Assam in terms of Executive Instruction number 162-C within a period of
10 days, you know?
period of 10 days from today. Stop. Thereafter, the Director of Land Records and Service Assam shall consider and dispose of the appeal as expeditiously as possible, but not later than 2 months. 2 months from the date of receipt of the appeal. With the aforesaid observations and directions, the writ petition is disposed of.
But as per my submission, you know, as per there's the notification, there should be not regarding appointment. It is only for that transfer or that is called confirmation or set aside order.
That we know.
But that is whether that is included or not. That is not included.
That you file an appeal because it is
No,
an
I'll file, my lord.
appointment of the other party.
5,
No.
May I please, your lordship?
Yes.
The petitioner, my lord, she was appointed, my lord, as ASHA worker, my lord, in 2013, my lord. And while she was working, my lord, her husband died in 2018. And she remained absent, my lord, for 1.5 months, my lord, in her duty. And one person was, my lord, temporarily engaged in her place. Thereafter, my lord, she joined in her post, but she was not allowed to work. Then, my lord, she filed representation before the authority, my lord, but no action has been taken. So, in my humble submission, or notice may go, my lord, and during pendency of this case, my lord, my representation may be considered now.
Yes, who appears
It's it. I place for the mission director, your lordship, it's for number 2.
for the
Mission director, National Health Mission.
My lord, I appear for the. I am appearing for the, my lord, 1, 3, and 4, my lord.
But Mr. R.
But my lord, in the petition, nothing is there, my lord. It's a vague petition, my lord. When she was absent, my lord, where and her joining her appointment letter, nothing is there, my lord. And if her husband died in the year 2018, if she was absent during that point of time, now, my lord, the petition is time barred in that case, my lord. It is a vague petition, my lord. Nothing details is there, nothing document is there, my lord.
Let them produce record, my lord, my appointment. They did not issue, my lord, appointment letter. ASHA worker, my lord, identity card has been issued. ID card has been issued, my lord.
If she doesn't
I
have
have
any
annexed, my
appointment
lord.
order, my lord, then she
This is
doesn't
a
have any case.
voluntarily, my lord, under the
there should
scheme,
be
my
an
lord.
appointment order, isn't it?
My lord, I have issued, my lord, the annex, my lord, the identity card issued by the, my lord, respondent of 4 department, my lord. Page 11, my
ASHA
lord.
worker, my lord,
Lost.
First, R. Learned Counsel for the petition issue notice. Mr. V.V. Bora, Learned Standing Counsel Health Department appears for respondents 1,
3, and 4, my lord.
3, and 4, and MS.
ADAS,
ADAS, Learned Standing Counsel
2, your lord.
NHM
NHM.
appears for respondent number 2. The petitioner will take steps for notice on respond number 5 by registered post AD within 1 week. List after 4 weeks. In the meantime, no, not say in the meantime, pendency of this writ petition shall not be a bar for the respondents to consider the representation made by the petitioner.
Lost.
Obliged, my lord.
6,
Please, your lordship. Your lordship, my father had died in harness on 25/10/2013. Subsequent to which, your lordship, I had applied for the compassionate appointment, your lordship.
Is it 25 or 15/6?
Your lordship, inadvertently, the the date was mistake. I was not
25.
25/10. And your lordship, then I had filed my representation and filed the application, but I had received no reply. Then I had filed a writ petition, your lordship, after which this court had passed an order. The order is at page 19, your lordship, where the honorable court had asked to consider my case and outcome of which was to be intimated to me. However, and subsequent to the court's order, your lordship, I filed my representation to the department concerned. However, I received no whatsoever reply. Then I wait for some time. Then I filed an RTI in 2023, your lordship. And so far, your lordship, I've been kept hanging and there's been no information communicated to me in regards to my appointment under compassionate ground.
Why are you coming so late?
Your lordship, I filed the RTI in 2023.
Before
And,
filing the RTA, what were you doing?
I was waiting for the reply, your lordship, and in between, COVID had also come and it had taken some time, your lordship.
Titya?
My lord, after
Whether DLC is considered.
whether considered or not, my lord, I would obtain
You
instruction.
take that
Yes.
instruction. Third MS,
M. Glory.
M. Glory, Learned Counsel for the petitioner. Stop. Mr. T.C. Titya, Learned Additional Senior Government Advocate shall take instructions as to whether the district level committee has considered the case of the petitioner. When do you want?
After 2 weeks, my lord.
At least after 2 weeks.
Like,
7.
Please, your lordship. The petitioner is in Havildar in the Assam Police Establishment, lordship. In 2018, petitioner was arrested in connection with a criminal case, lordship. Thereafter, he was placed under suspension, lordship. The suspension order is at page 20, lordship.
Yes.
And immediately after his release on bail, he was reinstated. I went the bail order at page 22, lordship. Thereafter, departmental proceeding was initiated against him, lordship, for indisciplined conduct and dereliction of duty. In the said departmental proceeding, lordship, the punishment of establishment of one increment without cumulative effect was imposed upon the petitioner, lordship. The said order is
Where's
at,
the order?
the said order is at page 32, lordship, annexure I.
Yes.
After that, lordship, in the criminal, after complaining of trial of the criminal proceeding, lordship, he was acquitted of all the charges.
Where's that equitable order?
That acquittal order is at page 33, annexure J.
Then
Operative part at 38, lordship. May I read, lordship? Order person.
yes, I read. Then what happened?
Thereafter, an appeal was preferred, lordship, to modify their punishment, lordship, but that appeal was rejected, lordship.
Where appeal? Where's the appeal?
Appeal order is at page 42, lordship, annexure K.
Yes, then
I have challenged this appeal, this order, lordship, and the imposition of a punishment, lordship. Since his involvement in the criminal case was not proved, lordship, so there is no dereliction of duty. Only because of his arrest he could not attended his duties, Lordship. And he was arrested for false yes, Lordship.
Yes,
Notice me, go, my lord.
but Mr.
M. Rana, Lordship.
M. Rana, issue notice. You are appealing for all respondents? Mr.
J.K. Parajuli.
J.K.
Parajuli.
Parajuli, then the governor enters appearance and accepts notice on behalf of all the respondents. Notice and respondents are complete, however, extra copies. Respondents are allowed to file counter affidavit. List after 4 weeks.
Obliged, Lord.
May I please, your lord?
Mm.
But what happened? My father was a permanent staff as a sweeper in the office of the number 6 at Forest Department at Tejpur. He died in the 2011. Since as a sweeper, then the post was lying vacant. Immediately they called me. I being the only son of my father, asked me to work temporary basis, honorary basis as a sweeper. Since 2000 December 11, I have been working as a sweeper. Initially, they paid me 2,000. Thereafter, another 2,000. Now I am getting 6,000. Still, I am working as a temporary. I have approached the Honorable Court, my lord. This is the judgment of the Honorable High Court. For appointment on compassionate grounds, judgment has been enclosed, my lord. That is page number 40, 40, your lordship will get it kindly. Honorable, our own High Court judgment, my lord, in connection with my prayer, my lord. And on the basis of the judgment, the respondent number 6 has placed my application to the DLC, but without any proposal of consideration. Appointment on compassionate ground.
Where?
It is mentioned, reflected in the order, my lord, in page 42, relevant portion, your lordship, top line, my lord. It has been mentioned that district level committee has not been able to take up the case of petition in view of the fact that no proposal for the petitioner's appointment on compassionate ground has been received in its office from concerned department. A copy of the state instruction is kept record in the mark number X. It is relevant to take up notice that state instructions are of the year 2019 and the council do not have any instructions of the present date. Then when at para 11, you will get para 11, 43. It is made clear that during the pendency of the instant writ petition, the respondent Forest Department have already forwarded the case of the petitioner to the district level committee for compassionate appointment. Respondent number 4. Then its directions issued paragraph 9 insofar as the appointment respondent Forest Department need not be complied with. However, they say the respondent Forest Department shall intimate the petitioner the details, which is the case of the referred respondent 4. Nothing has been done. My lord, I take your lordship to the time to time letter written by the respondent to the authority. My lord, first is page number 32. Your lordship will get. This is a letter from the conservator of forest, Northwest Circle, issue Tejpur. Page 32. Annexure 6. I have the honor to forward here the prayer petition number dated 11, along with the enclosures received from Sri Ganesh Balmiki, son of the late Ranjit Balmiki, sweeper of this office.
Was placed before the DLC.
But without proposal for appointment on compassionate ground. That has been reflected. Till today, nothing has been done. My lord, time to time, your lordship, our authority, Forest Department is writing to the authority that his post is lying vacant, he is getting a meager salary of 6,000 and full-time required.
What is this para 11?
Para 11 is of the judgment, my lord.
Yeah, page 43.
Yes. Para 11 says, it is made clear that during the pendency of the petition, the respondent Forest Department have already forwarded the case of the petitioner to the district level committee for compassionate appointment. Hence, the direction issued in paragraph 9, in so far the respondent Forest Department need not be complete. But nothing has been done till today. And my lord, subsequent letter your lordship will find from the Forest Department, they are pressurized, praying time to time to the authority. That is annexure 6, my lord. Then, my lord, I take your lordship annexure 7.
Yes,
Lordship, pursuant to this order, of the last writ petition, Lordship may come to page number 45. A letter was issued by the conservator of forest to the petitioner, asking him to submit the information or the application in a prescribed format.
Yes,
It was not submitted to.
We have submitted it. You have submitted it. Yes. We have submitted it.
Where is it?
That is not here, my lord. We have submitted to the office.
Have you stated that?
My lord, it is,
Have you stated that in a writ petition?
my lord, then my lord, let me take the instruction my lord, on this matter, my lord.
Hmm?
Let me say, yes, it is there, my lord.
Lordship, they have to submit the information in a
My
prescribed
lord, yes,
format.
there are 10 of my petition, page 10. The petitioner stated that thereafter the letter to 14/7/23, the respondent 5 directed the petitioner to submit the information as in prescribed format in the office of the memorandum dated 1/6/15. Although the earlier petition, it has been submitted that the respondent forest department has already forwarded the case of the petitioner to the district level committee of respondent 4. However, as directed, the petitioner has submitted the necessary information in prescribed format immediately as directed, but till date the case of the petitioner has not been placed before the before for consideration or recommendation of the competition department.
Yes, you take instructions.
Lordship,
Whether DLC has considered the case of the petition.
but he has to submit the information in a prescribed format.
That-
Only then
that-
we can forward
yeah,
it to the
that-
DLC.
If necessary, we'll file, I'll file again, my lord. But I'm working on a bigger amount of rupees,
But is
6,000.
was legal counsel for the petition. Stop. MS
M. Kalita, your lordship,
M. Kalita, then standing counsel,
for the forest department.
forest department shall take instructions. Whether the application of the petitioner has been forwarded to the concerned DLC. And who appears for the state? Okay, you take instruction.
My lord, date may be fixed. My lord.
List. When do you want?
Any day, as early as possible, within 2 weeks, my lord. Or 3 weeks as
List the matter on 18th.
Obliged, your lordship.
Aye.
May I please, your lordship? Your lordship, in this matter, your lordship, I have challenged the very inquiry report, the impugned dismissal order, and the dismissal of the appeal of the petitioner. Your lordship, before I take your lordship to the very annexures, your lordship, what has happened, your lordship? I had suffered pressure stroke, because of which I was admitted to the hospital, and thereby my leave was granted on the medical certificate for a period of 120 days. Thereafter, I was also granted 83 days further leave, which was an earned leave. And thereafter, your lordship, I had joined the service on 4/09/2015. Now, your lordship, the ASI of the police force had prepared an absent report on 29/8/2017, wherein he had stated that I was absent from 04/09/2015 for a period of 715 days. When the inquiry was conducted, he had stated in his statement that somehow or the other I was shown to be present at the police reserve deposition. Now I have challenged the very inquiry report, the impugned dismissal order, and the dismissal of appeal on primarily 7 grounds, your lordship. May I just take your lordship to the very inquiry report, your lordship?
This is notice by go, my lord.
Yeah.
Special matter.
Issue notice.
Yes, your lordship.
Heard, Mr.
DS Decca, your lordship.
Yes, they call and counsel for petitioner issue notice. You are appearing for
All the respond. All the
TC Chutia and additional senior government advocate and his appearance and accepts notice on behalf of all respondents. Accordingly, notice on respondents are complete.
extra
However,
copy.
extra copies of the petition before each. Respondents are allowed to file contra affidavits. List after 4 weeks.
Much obliged, your lordship.
10.
May please, your lordship.
My lord, in this case, my lord, the petitioner have challenged the selection process, my lord, pursuant to advertisement at page 37 for the post of district technical staff, district technical supporting staff. And the ground of challenge primarily, my lord, is that the advertisement was not properly notified in the public notice or in the newspaper, my lord. And my lord, the relevant guideline of selection, lordship will find at page 43 onwards, the annexure 16, the guidelines on what criteria should be considered. Page 47, lordship will find page 47, the criteria, terms and terms of reference. My lord, 1, 2, 3, 4, 5, 6, 7. My lord, 7 criteria is relevant for the petitioners, my lord. For candidates who had been serving under similar position under the under that or any other district administration in the state, 2 marks for each year of service offered could be awarded up to a maximum of 16 marks in the personal interview. My lord,
Before
This-
that, my lordship kindly see advertisement, he is not qualified. He does not possess the required qualification.
my
Yes, page 37. Page 37 and Extra 12. Advertisement. Name of the post, eligibility criteria. The candidate must be 21 proven education qualification. A candidate must be a graduate in any discipline. The petitioner lordship kindly see page 6 of his petition. He passed on the higher secondary.
no, my
He is
lord.
not qualified.
No, my lord, he is wrongly reading, my lord.
don't
I am
know.
for the second category post. The name of the post, district technical supporting staff. My lord, I am for this post, not this first one.
District,
District technical supporting staff. My lord. Here, my lord, eligibility criteria has been noted. The candidate must be 18 years of age and not more than 14 years of age. Qualification. The candidate must possess a valid minimum 6 months diploma in computer proficiency from a recognized institute and must have good working computer knowledge. The candidate must have 2 years experience in IT field and knowledge a person. My lord, I am having sufficient. I am 9 years. I am serving for the same post for 9 years. I am still working. My lord, the government earlier proposed for continuing our service, that we are rendering the same service, my lord, since 9 years back, 2014 onwards, my lord. Now, my lord, government initially, my lord, some communication is there. The government is decided to continue our service, my lord. Subsequently, my lord, the district authority has in their self style the advertisement. My lord, that lordship may kindly have an annexure 5 onwards, my lord. The government is decided to allow us to continue in service. But the district authority with my lord, ill motive, my lord, they wants to appoint other person and my lord, kicking out of ourselves, my lord. They have initiated the process of
Well, at least
selection.
notice may go, my lord. I will obtain instruction with file affidavit. So for advertisement.
And
is not
my
required, state
submission is, my lord, I am still working, my lord, but my remuneration since April 2023 has not been paid, my lord. That may be, my lord, directed to pay, my lord.
that will have to verify.
after instruction.
My lord, I have made a categorical statement in paragraph 21.
Then you take instruction, I won't issue notice today.
Yes, sir.
After that, I'll issue notice. Third year, Shifter, and the council for the petition. Mr. T.C. Shukdale and the addition senior government, which shall receive instructions in the matter. List on, when do you want?
My lord, some observation, but my lord, that pendency shall not be barred, my lord, if I am entitled to pay, to receive the amount, my lord, salary from April 2023, that may be considered, my
That
lord.
may be that.
Let him come, you take instruction 1 week,
No, 2 weeks, my lord. Is from Kacha.
we'll have it on 13th March.
And I am still working, my lord. That should not be disturbed, my lord. And my lord,
Let it come, let him come with the instructions. After that, I'll pass up.
He will provide 1 copy, my lord. Extra copy.
You finish one extra copy.
my lord. Okay.
11.
But the challenge here is my lord to a recovery order, my lord, at annexure 7. At the time of retirement, my lord, a sum of rupees 10 lakhs 38,691 was deducted from the gratuity.
And MSCP benefits thereafter also were also not, my lord, given. In May 23, finally, they said that we are reconsidering it and proposal has been sent. My lord, till now, my lord, nothing has happened, my lord. So therefore, this petition, my lord. As of now, I'm praying for notice only, my lord. There's no interim prayer.
Recoveries of November 2021.
My lord, recovery, they have not stated also for what reason it has been. There was no disciplinary proceeding against me. There's no reason also stated for. But I'm presumably understanding that there was some overstay of lay during the COVID period.
But Mr. P. Patna kindly come to the please. Issue notice. Mr.
UK Gupta.
UK Goswami, Leonard CGC,
Follow.
appears on behalf of all,
Follow.
all respondents. Notice on respondent incomplete. However, extra copies you furnish. Respondents are allowed to file counter affidavit list after 4 weeks.
12,
May please your lordship. My lord, the petitioner before lordship, he was appointed as an LDA in 1999. Then he was confirmed in the service. Then he was also promoted as UDA. Now, after serving for about 24 years, in March 2023, a communication came from the RCS to the Treasury officer to stop salaries of the petitioner as well as 8 other persons on the allegation that their initial appointments were invalid, and directed that their salaries should be stopped. Against that, my lord, the petitioner came before, and others, they came before this honorable court. And while the matter was pending, they have released the salary. Therefore, that matter has become infructuous. And it was disposed of with a direction that if there is any further action, you are at liberty to approach. Now, the RCS has now asked the government for approval to initiate proceeding in the disciplinary proceeding to terminate their service and also to refer the matter to some investigating agency. So I am aggrieved by the second part. Now, before that, may I take your lordship to page 31, which is the order primarily stopping our salary. Page 31. The petitioner, there is another item, item 51, my lord, same day appointment, same day promotion, everything, my lord. Now, they were appointed in 99, as I have already said. Now, this is a communication from the RCS, Register of Cooperative Societies, to the Treasury Officer, subject regarding illegal appointment of grade 3 and grade 4 posts under the establishment of Deputy Register of Cooperative Societies, Nagaon and Tezpur. In inviting a reference to the cited above, I am to say that the undersigned has initiated an inquiry upon the allegation on illegal appointments of grade 3 and grade 4 posts under the establishment of Deputy Register of Cooperative Societies, Nagaon and Tezpur. And on scrutiny, the matter on 18/3/2023, it was found that the following employees have been working under the directorate since long, having invalid appointment letters, orders, and without regularizing their services, they got their salary on regular basis till date. Therefore, you are requested not to disburse the salary of the concerned employees until further orders. So the name of the petitioner in this petition appears as serial number 7. And in item number 51, his number is serial number 2, Hridayananda Bora. Now, against this order, the petitioners approached this honorable court, and those cases have been disposed of. Effective part is at page 37. Third paragraph, after considering the submissions and developments which have taken place, namely that the salaries of the petitioners have been released, and this fact not being disputed, the court is of the opinion that the interests of justice should be served and the equities would also be balanced if the petitioners are closed with an observation that unless the due process of law is followed by adhering to the rules governing the field with regard to the declaring of appointments of the petitioners to be invalid, the petitioners would be entitled to the salaries. Further, since the salaries have already been released effectively, there may not be any live issue to be decided. In view of the above the discussions, the observations made, the petitions are closed. It is, however, made clear that in case of any adverse action, the petitioner would be at liberty to approach this court, and closure of this petition shall not be a bar for such action. then my lord, the impugn order at page 38 comes. This is a communication from the Registrar of Cooperative Societies to the government, secretary in the Cooperation Department, regarding irregular appointment in Cooperation Department. With reference to the subject cited above, I have the honor to enclose here with the enquiry report submitted by Pradeep Das DRCS, Sonitpur, regarding irregular appointment in Cooperation Department for favorable perusal. It may be mentioned that this office has already intimated the same wide letter on the reference to which the reply is still awaited. In view of the observations made in the aforesaid enquiry report, the undersigned seeks approval to start departmental proceeding for termination of service of the employees who were appointed irregularly, list of employees irregularly appointed, enclosed with the enquiry report. Furthermore, you are requested to refer the matter of illegal appointment to an investigation agency to conduct the investigation into the matter, a detailed investigation into the matter. Now, your lordship will notice that earlier, my lord, they stopped our salaries because they, my lord, we came before this court, salaries were released. Now they want to initiate the proper, my lord, the proceeding with a predetermined mind of termination. That part is also, my lord, all right, because, my lord, they can always initiate a disciplinary proceeding. But at the same time, referring the matter to investigating agency has a, my lord, serious consequence, because once, my lord, a case is registered, we may be arrested. And the fact remains that, my lord, in 1999 we were appointed. We have been confirmed in the service, promoted to the grade of UDA, and now all of a sudden this comes, and the action is sought to be taken against the petitioners who were appointed pursuant to a regular process of selection. If there is any, the order is invalid, then the person who has issued the order, the selection committee, against that also, my lord, order has to be, my lord, action has to be taken. Now this part, my lord, at this stage, my prayer is that your lordship may ask for the instructions from the government. Why, my lord, the criminal proceeding also? Because in the disciplinary proceeding, we can take all the defense. I do not say, my lord.
My humble submission, your lordship, the petition is premature. It is an internal communication, your lordship. No action, no step has been taken. No so-called notice has been issued here. And both criminal proceedings and your lordship, disciplinary proceeding can go separately, your lordship. At best, your lordship, I may take instruction at this stage, your lordship. Because inquiry report is not before us. We don't know whether the petitioner's name are there in the inquiry report.
Third M.K. Chowdhury, Learned Senior Counsel, assisted by Mr.
M.K. Bora.
M.K. Bora, Learned Counsel for the petitioner. Mr.
V. Rajpura, Corporation Department. V. Rajpura.
Raj Goel, Learned
Rajpura.
Standing Counsel,
Standing Counsel.
Cooperation Department,
Corporation.
shall take instructions with regard to the outcome of the letter dated 31/2024, written by the Registrar of Cooperative Societies, Assam, and addressed to the Secretary to the Governor of Assam Cooperation Department, within bracket Annexure 7 to the writ petition. Stop. When do you want list on? Next week?
Week time, maybe.
1 week time. So
2
we'll
weeks
have
time, 2 weeks.
2
Gotcha.
weeks. Just here.
Okay. 1 week's time.
We'll have it on 4th March.
Not on 4th, my lord. It will be on 6th or any other date. 4th, I may not be here.
6th March.
My lord, till that time, let them not take any coercive action, my lord. That will be till that date, my lord. Because only worry, only apprehension is that, my lord, anytime they can lodge an FIR and for career will be doomed, my lord. After 24 years of service.
But lordship will come to their appointment.
Okay,
Your
till
lordship.
the next suitable date, no coercive steps shall be taken against the petition. One
Right.
petitioner.
One petitioner in an item number 51 also, one petitioner, my lord. Exactly similar.
Item number 51 also same order. Is it annexure 7 here also?
Yes, my lord. Same.
No, here it's annexure 6. Oh, item 51 is annexure 6. Here it is annexure.
I'm sorry, but annexus 6.
Change that to annexure 6.
Highly obvious.
49 of supplementary list, Motion.
May I please, your lordship? My lord, page 20 is the order by which I was appointed, lordship. Page 20.
20. Yes,
Page 20 is the order, my appointment order, lordship.
yes.
Then, lordship, on the basis of some allegation,
What's your name? Serial number?
serial number 4.
Mm.
On the basis of some allegation brought by one colleague, I was barred from all kind of service, lordship, at page 29.
Mm. Yes.
Before issuing this impinged order, lordship, I was not given a chance to explain my case, lordship.
Mm.
That is my case, lordship. I was not heard, lordship. Lordship, allegation was brought by one colleague on 16. FIR was lodged on that day. I was taken into custody on 18/11. On that day itself, on production, I was released. Thereafter, I continued my service. On 22nd, I was barred from all kind of service, lordship. Without issuing any show cause notice, I was not even given a chance of explanation.
Okay, I'll have to get the instruction.
You want notice to go? You want to take instructions?
Yes,
Instructions.
Lordship, primarily they have not followed the principle, lordship.
Okay, whatever it is, let me take some instruction. Heard, Mr.
Am I Hussain, lordship?
M.I. Hussain, Leonard Counsel for the petition, Mr.
Upamanya for
Ubamanya, Leonard,
Standing Council
Standing Counsel,
Health and Family Welfare
Health
Department
and Family Welfare shall
for
take
1, 2, 4, and 5.
or shall take instruction. And let him take list on.
After 2 weeks.
No, lordship. Next date immediate, lordship, kindly.
Okay, 13th March.
Lordship, can it be taken in the next week, lordship?
No, lordship. I need some time.
Next week, lordship.
Let
Because
him get some instructions.
obliged, lordship.
50.
May I be lordship? Lordship, the petitioner herein applied for the post of rifleman recovery vehicle mechanic in Assam Rifle, my lord. He has qualified in all tests, my lord, but he was declared medically unfit due to having a tattoo in his right arm, my lord. The impugn order is page 20, my lord.
Yes.
That is the, my lord, unfit on account of having tattoo over inner aspect of right forearm.
Mm.
That is the unfit. And second aspect, my lord, in the bottom of this impugn order, my lord, the decision of the review medical board will be final. No appeal will be entertained against the finding of the review medical board, my
Mm.
in review medical examination. So there is a policy, my lord, that is page number 21, my lord, annexure 5. All other candidates, my lord, that is the permanent body tattoos are permitted on the following body part, only for which the candidate will be required to sign in a certificate as per the format of Annex D, my lord. That is the permissible, my lord. A and B, my lord.
Yes.
So my lord, my prayer is that my opportunity for the appeal medical board has also been rejected, my lord, by this impugn order. But in the similar issue, my lord, the honorable court has directed, that is the similar order, my lord. Next year, 6 page 30, my lord.
Here in this page 20,
My lord.
what does it say? CAPF recruitment guidelines.
CAPF recruitment guidelines, my lord.
Where
That
you are rejected. Tattoo.
tattoo, my lord.
Tattoo and deviated nasal septum.
Hmm?
On two grounds. Number one, tattoo over inner aspect of right forearm, and number two, deviated nasal septum.
Where is that?
That is like a displacement of the septum, which is the wall between the two nostrils, my lord.
But in review medical board, my lord, it has been found in for the introspect of that disease, but unfit only for the tattoos, my lord. Unfit on account of tattoo over inner aspect of right forearm. That is the reason of unfitness, my lord.
It's only for tattoo.
My lord. This is only for tattoos.
So you take instructions from
My.
But Mr.
V. Kumar, my lord.
Then I counsel for the petitioner issue notice. Mr. G. Bekul, CGC.
My lord.
Enters appearance and accepts notice on behalf of all respondents.
My lord.
Notice and respondents are complete. However, extra copies.
My one prayer, my lord, the post may kept vacant till then, my lord. Otherwise,
Respondents are allowed to file contra affidavit, list the matter after 4 weeks. Till the next reasonable date. One post of
rifleman recovery vehicle mechanics, my lord.
Where is that page?
That is in my call letter, my lord, next year 2, page 16. I have applied for the
Where is that?
my lord, kindly see page number 14, my lord. That is serial number 14, my lord, bottom side, serial number 14. B, column B, my lord.
Bottom side?
Bottom side, that is the state of Madhya Pradesh, my lord. That is paragraph number 14, B, rifleman recovery vehicle mechanics, my lord.
One post of rifleman.
Only one post is there, I suppose, my lord, here in the expert. So if one post is vacant, my lord, I'll get the instruction, my lord. That next date, my lord.
Within bracket, recovery vehicle mechanic, close bracket, shall not be filled up.
My lord.
Till the next reasonable.
Declare lordship.
52.
May it please your lordship. Lordship, transfer matter, your lordship. Impugn order, your lordship will find at page 70. In the interest of public service, Sri Abbas Ali, Senior Assistant, Office of the Inspector of Schools, MDC Morigaon, is hereby transferred at his own grade and scale of pay and posted at the Office of the Inspector of Schools, BDC Borpeta, against vacant post, vice late so-and-so, expired on so-and-so. No TA and DA will be admissible for the purposes. Your lordship, this order, just 1 month before, your lordship, I was promoted. The earlier page, your lordship, page 16, and lecture 2. This is 8/1/2024. My name is at serial number 1, Abbas Ali, Junior Assistant, promoted to the post of Senior Assistant in the Office of the Inspector of Schools, Morigaon. Now, what had happened, your lordship, this transfer order came to be issued, your lordship, pursuant to a question raised by the local MLA in the floor of the assembly, your lordship.
On 16/12, the question was raised, and on 16/12 itself, the impugned transfer order was passed. I have annexed the
Is it 16/12 or 16/2?
Lordship, I beg your pardon, 62, Your Lordship.
Hmm.
Page 30, Your Lordship, I have annexed the newspaper report wherein it has been reported. We have tried to find out the assembly minutes, but it was not available online, Your Lordship. Now, page 30, Your Lordship, may kindly peruse 5th line, Lordship. The translated newspaper report.
Hmm.
The heading is, Your Lordship, public interest, ignore Ramakanti Deori raises question in assembly for transfer of clerk. Senior assistant of Morigaon Education Department transferred to Barpeta. Now, from the 5th line is relevant. This is 18th February. BJP MLA from Morigaon constituency, Sri Ramakanta Deori had on February 16 raised a question in the Assam Legislative Assembly under question number 34 to the divisional minister, who would inform as to why the assistant Abbas Ali, who had been working for 25 years at the office of the inspector of schools in Morigaon, has not been transferred. This was followed by the inevitable transfer of senior assistant Abbas Ali in an order issued on February 16th by the director of Assam Board of Secondary Education, Mamta Hojai, transferred Abbas Ali, senior assistant of the office of inspector of schools Morigaon, to the inspector of office of Barpeta District School. Now, page 29, Your Lordship, the earlier page, is the gradation list that I have annexed, Your Lordship. Page 29. My name is at serial number 1, Abbas Ali, date of birth 1968, date of appointment 1994, joined as LDA 1994, joined as UDA. It should have been 10/1/2024, Your Lordship. Caste general. Your Lordship,
It's 10/1/2024.
10/1, Your Lordship. This is a typographical error. Pursuant to the 8/1 that I have placed, Your Lordship, the 10/1 I had joined. Now, Your Lordship, from this gradation list, it's clear that the cadre is only at the district level. It's not a state cadre, Your Lordship. I am in a clerical post. Under the ministerial service rule, Your Lordship, district cadre forms a separate cadre. And I have been transferred from one cadre to another only on the basis of a question raised by a MLA, Your Lordship. That is also arbitrary. There are judgments of this Honorable Court, Your Lordship. I'd like to place the rules and the judgment. And Your Lordship, the state level, this promotion exercise that was undertaken, Your Lordship, this record only I have received today. Today I have received, Your Lordship. In every state, separate exercises were carried out. For promotion from LDA to UDA, in the offices of the inspector of schools, district level promotions were made, Your Lordship. So each district level cadre, it's a district level cadre. Inter-district I can be transferred, but outside district, as per rule, I cannot be transferred, Your Lordship. That is my contention. And secondly, at the instance of a MLA question raised by MLA, judgment to decide. Lordship may just kindly peruse the judgment.
Yes.
Judgment, Your Lordship, paragraph 12 and 13, the ratio has been laid down. This is first. Paragraph 12, what appears from the facts above, more so from the notings in the file number so-and-so, is that the order of transfer was set in motion only at the instance of the MLA concerned. Under no circumstances, the said order of transfer can be termed as a valid exercise of power, uninfluenced by any opinion of any other authority, including the MLA concerned. The interference by the MLA and the resultant effect strikes at the root of the notification dated 1/3/2016. That is the impugned transfer order in this case. Also important to note, the notings in the aforesaid file do not show any independent application of mine and or the ground realities that the Commissioner and Secretary PWRD was required to satisfy itself from his own personal judgment in the matter. What had been done is only a reiteration of the notes put up by his subordinate authority, which he had only passed on to the minister concerned. The facts above clearly shows arbitrariness on the state of the respondent authorities in issuing the notification dated 1/3
2026. The element of public interest is singularly absent, each case being an authority for what it actually decides. Reliance based in so-and-so does not come to the aid of the record. Your Lordship, this hearing arbitrariness is present, Your Lordship. Pursuant to the question raised by the MLA, my transfer was made, and the separate bunch I have given only today I have received this, Your Lordship. That's why I could not annex in the writ petition. These are the promotion order, district-wise promotion order, 18 districts. To Gyan. Lordship, further, actually, Your Lordship, my wife is suffering from a disease, severe gastritis, grade 3, and my son is appearing in the matriculation, Your Lordship, this year. These are all, Lordship, district-wise orders, Your Lordship will kindly peruse. This is the first order is of Kamrup Metro, Your Lordship. Second page is of Dibrugarh. My transfer order here is at page, in that I have page work, Your Lordship, page 5 from the start. Promotion order, 8/1/2024. This I have annexed in the writ petition. This is Abbas Ali, serial number 1. This is Morigao. 2 incumbents were promoted. And Borpeta district, wherein I have been transferred, from the last, I have page number 5 from the last. One incumbent was promoted, Hitesh Pathak. And I have been transferred to therein to a post which has arisen out of vacancy of out of death of another incumbent. So as such, public interest is not present in the
That we'll see after the producer records.
And Your Lordship, district-wise cadre, Your Lordship, in the rules.
Which rule?
Lordship, Directorate Establishment Ministerial Rules, 1973.
Page?
Lordship, mine is the old edition. Page 170. Start set, put 168, Your Lordship has the Assam Directorate Establishment Ministerial Service Rules, 1973. Now, Your Lordship will kindly peruse Rule 3. This is cadre. Rule 3, under the heading cadre service. Rule 3.3, Your Lordship. Each of the categories of posts mentioned in sub-rule 2 shall form an independent cadre. Members of a lower cadre shall have no claim for appointment to any of the higher cadres except in accordance with the provisions made in this rule. So Rule 2C reflects the post of senior assistant, Your Lordship. And the status of my service is given in Rule 4. Rule 4, Your Lordship will see, sub-rule 2, the status of the registrar and superintendent shall be that of class 2 gazetted ministerial service, and that of other staff shall be of class 3 non-gazetted ministerial service. So I, being a senior assistant now, I will come under class 3 non-gazetted ministerial service. Your Lordship. So these people, usually, Your Lordship, clerks, are they join at a certain place and they retire there throughout their entire career. Only because of this question, I have been transferred. Even I was promoted as a senior assistant in Morigao itself 1 month back. So only out of political interference, this is happening. And otherwise, Your Lordship, his wife is seriously sick, Your Lordship, gastric. He is suffering from gastric. And I have annexed the medical records, Your Lordship. Page 23. This is a report. Page 23, Your Lordship. Bottom part, Your Lordship will find. the endoscopic diagnosis, erosive antral gastritis, small antral ulcer, forest 3, that is grade 3. So he is perpetually sick, you know. I have to look after the office as well as the home. And my son, your lordship, is appearing for the HSLC examination this year. I have annexed the admit card at page 27. This is page 27 of the petition. Candidate's name Sahil Ali, father's name Abbas Ali, mother's name Sharif Amira. Lordship, and page 28, next page, this schedule is annexed, your lordship. Now the exams are taking place, you know. And your lordship, I have only 4 years of service left, you know. Now at the fag end of my career, I have been transferred to a place which is almost 300 kilometers far away.
Yes.
That is the lordship notified you to lordship. I will obtain instruction lordship until the next on the next returnable date.
Have you joined?
No, your I am on leave, President.
Huh?
I am on leave, your lordship, due to this examination of my son. Lordship may kindly stay the effect, operation and effect of the interim order, the impugned order till the next date. Let them produce the record.
Where is that order?
Impugned order, page 17, your lordship.
But Mr.
Zizad Ahmed.
GZ Ahmed, counsel for the petition. Stop. This is the case of the petitioner. No, cancel. The petitioner is agree with the order dated 16/2/2024, by which he has been transferred in his own grade and scale of pay and posted at the office of the Inspector of Schools, BDC Parpita, against vacant post. Vice late Deepak Kumar Banik, Senior Assistant, who expired on 19/1/2024. Stop. Para. It is the case of the petitioner that he belongs to the District Ministerial Service.
Lordship, under this Assam Directorate Establishment,
That he belongs to the Assam Directorate Establishment
Ministerial Service Rules,
Ministerial Service,
Service Rules, 1973.
and no, don't say like that. It is the case of the petitioner, cancel it, rewrite that he belongs to the Directorate Ministerial Service, which is governed by the Assam Directorate Establishment within bracket Ministerial Service Rules 1973, whereby your transfer is not permitted.
Not permitted. Yeah, because district cadet, it's not a state cadet.
Whereby the transfer of the petitioner to Barbita is not permitted, inasmuch as he belongs to the directorate.
Class 3 non-gazetted ministerial service.
He belongs to the class 3 non-gazetted ministerial service. Stop. The further case of the petitioner is that on the day or that his wife is suffering from erosive antral gastritis and she needs medical attention for which the presence of the petitioner is required. Stop. It is also the case of the petitioner that his son is appearing in the Board of Secondary Education examinations, which commence which commenced from 16th of February 2024 and will end on 4th of March 2024. Correct?
Yes, sir.
Stop. Para. No, don't say para. Stop. The petitioner therefore submits, it is therefore the case of the petitioner that he has been transferred only on the intervention of the local MLA. Local MLA, isn't it?
Yes, sir.
On the intervention of the local MLA, and there's no public service involved. And there's no public, and it is not in the interest of public service. Stop. Para. Issue, issue notice. Mr.
T. Thakuria.
T.
T. Thakuria.
Thakuria.
T. Thakuria.
T. Thakuria. Learned Standing Council.
Education Department. Secondary Education Department.
Secondary Education Department.
1, 2, 3, and 4. That's one of all that's on the-
Appearance and accepts notice on behalf of the respondents. 1, 2, 3,
and 4.
and 4. On behalf of all the respondents.
Yes, sir.
Stop. Notice and respondents are complete. However, extra copies be furnished to so and so on. Respondents are allowed to file.
Give me 1 week time, Lordship, and after obtaining instruction, Lordship, interim time may be considered on that day, Lordship. After 1 week, is interim time.
Your leave till what?
I will obtain it. Now he is on leave also, Lordship. So nothing will happen, Lordship.
Next day,
Only
if he
one-
produces the records, it can be disposed of, your lord. After
Only
2
1
weeks.
week, Lordship. On that day,
After 2
Lordship,
weeks.
interim time may be considered. On that
No,
day.
no, then you can.
No, your
don't
lordship,
just-
today, your lordship,
Don't say issue notice, all this.
lordship may stay, no, your lordship may kindly stay.
1
the-
minute. Mr. Spencer, Learned Standing Council, School Education Department, press for a week's time
Yes,
to
one-
enable him to receive instructions and also produce the records. The press allowed. Till the next schedulable date, the order dated
16 to your.
16th to 2024, by which the petitioner has been transferred as senior assistant to the office of the Inspector of Schools, BDC, Barbita, shall remain state. List on, give a date.
Yes.
Next week, we need to look.
Monday?
Next month.
No? 4th of March.
4th March.
13 of daily list,
What's up?
complement of party.
Wait, please, your lordship. This initial application has been filed, my lord, for implement of the present secretary to the Gupta Avastha, my lord, Water Resource Department, my lord. He had been communicated, duly communicated, my lord, and he had received the notice also.
Where?
Page 12, my lord. There is the delivery report, my lord.
Page 12. When was it delivered? 1/1.
Yes.
How much time was given for compliance?
My lord, it is almost 1 month here. Yet.
Okay. Who's the secretary, Water Resources?
My lord, yes, Abbasi, my lord.
How many respondents are there in the contempt?
My lord, there was initially only one, my lord, Ananta Kumar Bora, my lord, but he has been retired, my lord. Now, my lord, present incumbent is there.
No, in the contempt, there are two respondents.
Now, my lord, earlier, hints, my lord, Ananta
No,
Kumar Bora was,
in the contempt, there are two respondents, isn't it?
yes, my lord.
No, my lord, contempt is initially one, my lord.
Check up your contempt petition. One respondent. One respondent.
My lord.
Earlier, you had also filed an IA.
My lord, yes, my lord, but that was not listed, and in the meantime, that incumbent has already retired, my lord.
Okay.
That has become infectious, my lord.
This IA 3019.
Yes, my lord. That has become infectious.
Okay, IA 434. Heard Mr.
Yes, sir.
S. Huck, learned counsel for the petition. By this application, the applicant is praying for implementment of Shri S. Abasi,
Right.
comma, IS Secretary to the Government of Assam, comma, Water Resource Department, Assam, Dispur, Guwahati 6, as party response number 2. In contempt case number 396 of 2016, on the ground that the earlier incumbent has, that the respondent number 1 in the contempt case has retired, and the said incumbent is presently holding the post. Stop. After perusing the cause shown in the present application, the prayer for implementment is allowed. I is disposed. In the main contempt, in view of the order passed today and so and so, let so and so be implemented as party response number 2 in the present contempt petition. Stop. Para. Issue notice to the newly implemented response number 2. Stop. Petitioner to take steps for service of notice within 1 week from today. List the matter up to 4 weeks. The petitioner is also directed to file an amended course title within a period of 1 week.
Well,
1 week from today. Stop.
I'm appearing on behalf of respondent number 1, P. Kakoti.
Mr. P. Kakuti, Learned Counsel appears for the respond number 1.
my,
Obliged.
And the IA 3019, this is in fact
that has become infectious.
Mr. S. Huck, Learned Counsel for the petitioner, for the applicant submits. But the present IA has become infectious. Accordingly, the same is disposed of as infectious.
I'm afraid.
Accordingly, this IA is disposed of.
15, admission.
May I please, your lordship?
Yes.
Matter pertaining to non-regulation of the service of the petitioner from the date of his initial appointment, my lord. He was appointed in 17/5/1996, my lord. In 1999, FIR was lodged against him, my lord. On the basis of the FIR, my lord, he was suspended. Page number 18, my lord. And no DP was initiated against him, my lord. So he was reinstated in his service in page number 19, my lord. But in the same case, he was convicted. So he was dismissed from his service in 2000, my lord.
Where's the conviction order?
My lord, conviction order is not endorsed, but he was acquitted, my lord, from the charges, all charges.
Oh, he was acquitted. You said
Yes, my lord.
he was convicted.
Convicted, then he appealed in High Court, my lord. Criminal appeal was filed, and he was acquitted from all charges. After acquittal, my lord, he was reinstated again. Page number 31, my lord. Page number 31, the last para, my lord. Hence read. May I read, my lord?
Yes.
Well, page number 31, the last paragraph. Mr. Ratneswar Bora is hereby reinstated in his original post of Mondal from the date of his joining. He has been posted temporarily in the vacant post under Doboka Revenue Circle. But he was not, my lord, reinstated from the date of his initial appointment, my lord. So he submitted representation before DC, my lord. DC,
No, he should be reinstated from the day of dismissal, is it?
my lord,
Not initial appointment.
initial appointment. So he,
Initial appointment or from the date of dismissal?
my lord, he was appointed in the, from the date of his, from the date of his order, my lord,
Huh,
not
that's what-
from the initial appointment, my lord. But 1996 was his initial appointment date. 17/5/1996.
No, you were appointed regularly.
Yes, my lord, I was regularly
So
appointed.
you were regularly serving
Yes, but
till your dismissal.
my lord,
So your reinstatement should be with effect from the date of dismissal, isn't it?
yes,
Not from the date of
initial appointment.
not from the date of initial appointment.
My lord. That's why,
Hendrik, have you filed your affidavit? Or are you appearing in this matter?
Lordship, I am appear on behalf of respondent number.
my lord, I have filed various
Respondent
revisions.
number 1 and 2, Lordship. We already been committed, we have not received any instruction, my lord, that, regarding this. And my lord, even then, my lord, as per the service rule, Lordship, my lord, disciplinary appeal rule, my lord, there is a provision for appeal, Lordship. My lord, that section 16, rule 16, Lordship, sub-rule 2, sub-rule B, D.
When was this order passed?
My lord, page number 39. I have filed various representations on the basis of my representation. My lord, in my representation, I asked for the arrear salary for the period of my dismissal, which for regulation of my service, my lord. They have mentioned that I am not entitled for the regular arrear salary, but they have not mentioned about the regularization of my service, my lord, in page number 39. No DP was initiated against me, my lord. In the report of DC, it's chronologically mentioned, my lord. In page number 36. DC informed Revenue Department, my lord, government, that no DP was initiated against.
What is taking you so long? When was this petition filed? 2020?
20, Lordship,
Then-
20 has been filed.
Pending.
And Lordship, my lord, that this period, my lord, he was not in service.
No,
That
my
is a
lord.
different issue.
Different issue, Lordship, better, my lord, no pay, my lord, he was not working. my
No
lord.
work, no
Did not
pay,
pay.
that is a
And,
different issue.
my lord,
But
yes.
how about his reinstatement?
My lord, I am going to retire in 2025 January, my lord.
Then
Well, let me obtain instruction, file an affidavit, my lord, clarifying all this.
have you received instructions?
No, Lordship, yet to be received. We already been communicated, Lordship, on my lord, 9/10/23. They have, my lord, given one instruction, my lord, that they already been asked the deputy commissioner to establish detail.
My lord,
It's not a
Deputy Commissioner report already I have enclosed, my lord. My lord, page number 38, relevant, 36 is translated. Type copy, my lord. DP already, DC already kept. My lord, I am going to retire in December, January 2025. It will hamper my pension also, my lord.
And Lordship, may kindly turn to the page 33. The circle officer, my lord, was written a letter to the deputy additional DC, Lordship. He stated that my lord, that regarding
Hurt, MS,
no record is available.
M. Das,
My lord.
General Counsel for the petition. On request made by Mr. J. Hande, the Standing Counsel, Revenue Department.
Lordship.
Release the matter after.
My lord,
After
one,
3 weeks, Lordship. Well, it will take time, my lord.
my lord, date may be given
Lord.
because person is going to be.
Okay, on request made by J. Hande, when the Standing Counsel is given, 3 weeks' time is allowed to enable him to receive instructions and file affidavit. List on, this is 1 week, 2 weeks, 3 weeks. 20 March.
My lord, obliged, deeply obliged.
16.
In this case, not a Philippine opportunity has been filed. By the wings, they are not present before your lord. So your lordship at this stage, you can issue rule and fix the date of hearing.
You're not filing reply?
Yeah?
You're not filing reply?
No, I'm not filing it.
Mr.
A. Dasgupta.
A. Das Gupta, Learned Senior Counsel. Learned Counsel. Learned Senior Counsel submits that he is not filing reply to the affidavit filed by the respondents. Stop. Accordingly, issue rule. As all parties are represented, no formal steps are required. List the matter for hearing. When? After?
March, in the month of March.
In the month of March 2024.
Date may be written, if possible.
List the matter for hearing on 19th March.
17.
But the issue involved here is, my lord, dismissal from service on the ground that, my lord, the petitioner had earned 4 rating entries. My lord, in paramilitary forces and also in the armed forces, there is a procedure that if you are a habitual offender and if you are warned several times at one particular point of time, you can be discharged from service. Now, the law that has been evolved, my lord, by the apex court and by virtue of different notifications is that this nature of offenses has to be considered. My lord, in my case, if your lordship takes up their affidavit, otherwise it's a very simple matter and the law is settled. If your lordship
People, you are ready?
I'll just begin from their affidavit, my lord, as to see what I have done. Phase 2. Phase 2 of the affidavit filed by the Samaracals.
30.
Running page would be 30. नहीं किया ना it says the firstly he earned a 3 days rigorous imprisonment in Assam Rifle custody under section 35.
No, you're reading from where?
From the affidavit of the Assam Rifles. Affidavit in opposition, internal page 2 of the affidavit of the Assam Rifles. It should be the running case number 30. Lordship has got it. First offense is, my lord, of intoxication. He was punished for 3 days. The second offense is, my lord, of 7 days rigorous imprisonment, my lord, for overstaying leave by 11 days. The third offense is, my lord, again of overstay of 35 days. Now, there's no pattern, my lord. It's not that he is a habitually intoxicated person and therefore he has been discharged. Overstay of leave, my lord, I had represented as to what difficulties were there for which I could not join within the sanctioned leave period. And these leave periods have been subsequently regularized also. And finally, why I am thrown out, my lord? Because I have, fourthly, I have lost my I-card. My card was stolen, my lord. What can I do if a thief takes, my lord, something from my luggage? From transit, the I-card was lost.
Okay.
And for that reason, I am thrown out, my lord. There's no...
After 5?
My lord.
any repetitive pattern of being a habitual offender of a particular kind. And particularly the fourth offense for which I am thrown out, my lord, it cannot be considered to be an offense at all. Anybody can, my lord, lose some valuables or documents, my lord. How can I be held responsible for the same, my lord? It's not that my weapon, service weapon is lost. For that, I'm responsible. If my service weapon is lost, I have to be in proper custody of the same. It indicates a severe neglect on my part. But losing of the I-card can be reissued at any point of time. How can that offense be taken as the ground of throwing me out, my lord? In this aspect, my lord, there are two decisions of the apex court, my lord, I'll be relying upon. Lordship has a look, and Virender Kumar Pandey, and Virender Kumar Dubey, and Amarendra Kumar Pandey, my lord. In both these cases, my lord, the apex court has interfered with such kind of punishment. Virender Dubey is the first case, my lord. 2016 to SCC 627.
Yes.
Take your lordship to para 10 of Virender Kumar Dubey straight away. Says the government, as rightly mentioned by the learned counsel for the appellant, stipulated not only a show cause notice, which is an indispensable part on requirement of the rule, but also an impartial inquiry into the allegation against him, in which he is entitled to an adequate opportunity of putting his defense and adducing evidence in support thereof. More importantly, certain inbuilt safeguards against discharge from service on 4 edict entries has been also prescribed. The first and foremost is an unequivocal declaration that mere award of 4 reading entries to an individual does not make his discharge mandatory. This implies that 4 reading entries is not some kind of a Lakshman Rekha, which if crossed would by itself render the individual concerned undesirable or unworthy of retention in the force. Award of 4 reading entries simply pushes the individual concerned into a gray area where he can be considered for discharge. But just because he qualifies for such discharge does not mean that he must necessarily suffer that fate. It is one thing to qualify for consideration and an entirely different thing to be found fit for discharge. 4 reading entries in that sense take the individual closer to discharge, but does not push him over. It is axiomatic that commanding officer is, even after the award of such entries, required to consider the nature of the offense for which such entries have been awarded and other aspects made relevant by the government in the procedure that it has prescribed. So even if I am awarded a 4th reading entry, my lord, for losing the I-card, my lord, the gravity and the nature of the offense, my lord, is to be considered. Which in my humble submission, my lord, they have exceeded that part and without any inquiry thereafter, without any show cause therefore, without any procedure thereafter, simply just because I have reached this threshold of 4 reading entries, I was thrown out from service, my lord. In this case, my lord, at para 21, therefore, the order of punishment was interfered with. This Virendra Kumar Dubey is, my lord, reiterated in a more recent judgment in 2022, my lord. In para 22, Amarendra Kumar Pandey, para 22, says, we must first look into the decision of the court rendered in the case of Virendra Kumar Dubey Supra.
Yes.
We must first look into the decision of the court rendered in the case of Virender Kumar Dubey Supra. In the said case, the appellant Virender Kumar Dubey was enrolled as an operator in the Corps of Artillery of Indian Army in 1980. Having served in his capacity for 12 years, he received a show cause notice pointing out that he has been awarded 4 rating entries for various offences
set out in the notice, and Virender Kumar Dubey had become a habitual offender, thereby setting a bad example of indiscipline in the army. Virender Kumar Dubey was discharged from service by order dated so and so. He had preferred a departmental appeal which had failed. He had thereafter went to the High Court, Madhya Pradesh, and so and so. He had thereafter preferred an appeal to the appellate court, and so and so. Thereafter, my lord, the findings that we just read, my lord, from Virender Kumar Dubey's judgment, my lord, has been reiterated, my lord. And in this case also, my lord, the aspect of being a habitual offender and the gravity of the offenses were taken into consideration.
Where?
In fact, following Virender Kumar Dubey, my lord, in 2021, the Assam Rifle themselves issued an advisory saying as to how and what procedure is to be followed. If Lordship has a look into this advisory. The same thing is reiterated here, my lord, saying that incurring forwarding interest is not mechanical process by which a person would be discharged away from service, and therefore the termination of service has to be judged by the facts and circumstances of each case. The second page of the advisory, Lordship would see. I said 21. Dubai represented.
Were you given notice
Notice I had asked the so first. No.
before your discharge?
Ah. Yes, my lord, page 17, page 23.
Page?
20 is page 17, my lord, of the writ petition, and exercise 3. Thereafter, if your lordship sees, in page 19, they have just mechanically said that no inquiry was conducted. There's mechanically said that my
Page?
show was my page 19. They mechanically said that my show cause reply was not found satisfactory, and therefore you are not fit to continue in service. My page 19, it's dated 15 January 2020, Annex of 4. They have used the word incorrigible offender, my lord. And that aspect of gravity of offense and being incorrigible, because there's no habitual or repetitive offense being conducted. And particularly my emphasis on the port reading entry, my lord. Loss of I card, my lord.
Where's the impugned order?
Annex of 5, page 20. Annex of 5, page 20. Page 20, Lordship, whereas it is considered that the conduct of rifleman so-and-so of 7 Assam Rifles, which has led him into getting poor rating entry, is such as to render him his further retention in public service undesirable, being an incorrigible offender and having shown no improvement during his service. So he's dismissed, my lord, as being an incorrigible offender, which in my humble submission, the facts and circumstances, my lord, do not establish so, my lord.
He's neither a habitual drunkard or neither, my lord, he is a habitual absentee also. And the fourth rating entry, my lord, is totally preposterous. Just because of loss of I-card, somebody is thrown out of service, my lord.
Yes.
My lord, that is my simple case, my lord. These are the only points that I urge, my lord.
Yes, my lord. My lord, here, my lord, the case is that the petitioner was tried summarily on 4 occasions, my lord. And every offense, my lord, he was administered with repeated counselings by the authorities, and also a warning letter was issued, but the petitioner did not show any improvement, my lord. So on the 4th occasion, my lord, when he has lost his identity card, my lord, he was declared an incorrigible offender to the government. And according to under section 11 clause 2 of the Assam Rifles Act, my lord, Federal Rule 17 and 15, he was discharged from service. And the issue here is, my lord, since Assam Rifles is a disciplined armed force, my lord, gross discipline on the part of the employee cannot be countenanced. So I would like to place 2 judgments, my lord.
No, what do you say on the four rating entries?
My lord, warning letter, SOCOS was issued to him. He has filed his reply, and accordingly, the authority has. Since he has habitually violated the rules of the unit.
No, on these 4 entries, what do you have to say?
Because this rating entries, I am not contesting, my. The result that has come from the rating entry, that the apex court has said, it has to be considered differently. I have been put in probably a gray zone, my lord, that I have to be careful. But then that does not mean automatically, my lord, I will be discharged, which they have done. They have automatically discharged me just because I have uncourt rating. No independent application of mine.
Page 5 of my affidavit, my lord, page 5. The SOCOS notice was issued to the petitioner by the DIG and given him 15 days time to send his reply. And the SOCOS notice was received by him, and the reply was received on 14/11/2019. And it was considered by the competent authority, my lord, and was found to be unsatisfactory, lacking any merit. And therefore, the department has decided to discharge the petitioner from service.
No, that's fine. That's probably the way you have gone into, but how do you explain these 4 rating entries? 1, 2, 3, 4, how do you defend them? One is
Intoxication, yes.
one is absence.
Absence, delay in joining for 11 days, and another one is for 35 days, and the fourth one is for losing the ID card. So on every offense, my lord, rating increase for me. The total four.
No, Supreme Court has said all the four entries does not automatically mean that he
So
should.
that is why I would like to place the judgment of the recent judgment of the Supreme Court, my lord, where it is said, my lord.
Hold on, sir.
First, I would like to draw your lordship attention, my lord. 2023 9 STC 100 ex Sukhoi Madan Prasad versus Union of India and others. Ex Sukhoi Madan Prasad appellants versus Union of India. Paragraph 17. For the aforesaid reasons, I read it, my lord. We do not find any infirmity in the impugned judgment passed by the AFT. The appellant has been taken too many liberties during his service, and despite several punishments awarded to him earlier, ranging from imposition of rigorous, he did not mend his ways. This was his sixth for the same offense. Therefore, he did not deserve any leniency by infliction of punishment lesser than what has been awarded to him.
It was his sixth offense.
Six offense and all of my lord overstay of lay. Lordship would see that.
And another one, my lord.
20 days, 11 days.
Union of India versus.
1 minute.
It's all of overstay of play. So a repetitive pattern of being an incorrigible offender is established in this case.
Here also, my lord, there were 4 red entries.
Where?
In that Madan Prasad case. Another one, my lord, Union of India versus Constable Sunil Kumar.
Oh, here there were six red ink entries.
4 red entries and 1 black ink entry, my lord.
Which is even worse.
Total 6.
Total 6. The 6th time he was, my lord, taken out because it's all relating to, my lord, overstay of lay.
Here and another case, my lord, Union of India versus Constable Sunil Kumar. Here, the offense was he was found in an intoxication when on duty. Only for that ground he was dismissed from service. 2023.
That is a serious offense.
Yes, and I think in this case, my lord, he misbehaved also with the officer after being intoxicated, my lord, which is a very serious offense, of course. Only one offense in those cases is, my lord.
Here, out of these 4, my lord, one of the offenses he was offense was of intoxication.
But then there is no allegation of misbehavior.
Was the intoxication during the period of his duty or off?
Yes, during the duty, man.
How do you say that?
Yes, my lord, that is why, my lord. He has never.
Where's that? Where have you explained that while he was on duty, he was intoxicated?
Page 51, sir. Page 51 advice of his affidavit, he says that page 51 internal of his affidavit, the running page 51, lordship. Running page 51. He says that intoxication that he had failed on 18 September 2017 at 8:30 hours was found in a state of intoxication.
Where is that?
It would be internal page 51, my lord. Sorry, running page 51, internal page 23 of the affidavit of the Union of India. But then it does not say specifically that he was on active duty, my lord. And the other case, basically, I know that in that case, he was drunk and he misbehaved with the
Annexer 1, my lord, Annexer 1. At page 23, Annexer 1 of our affidavit.
That is what I'm pointing out, my lord. Page 51,
or 52.
running page would be 51.
In that he at field on 18
September 2015 at 08:30 hours was found in a state of.
What is at field?
Definitely on duty, my lord.
No, this does not indicate that he was on duty. How many days do you have for return?
Yes. Superannuation is of 60 years, my lord, and he had completed 11 years of service. No? He had completed only 11 years of service. It was 34. Another 20, more than 20 years of service left, my.
Paragraph 13 also of that Sunil Kumar.
Para?
Paragraph 13, Union of India versus Sunil Kumar.
Yes.
So, my lord, the department was right in passing the order on discussing the petition of Contempt. Because discipline in an armed force is a like a non-negotiable condition of service.
That is a different thing. That is a different issue. But then the direct discharge from service after 4 rating entries, that is also not going according to your guidelines issued by the ministry. Isn't that? And as well as by the Supreme Court.
In serious cases,
You have to get into the gravity of the matter. See, like losing the IT card. He might have lost in some other circumstances which he cannot help it. What do? It comes back to three. Supposing we take that intoxication and the period of absence, 3 rating entries. This is okay. But the fourth one, and even if there's a fourth one, then you'll have to consider whether with regard to the gravity of the offense. Have you considered all this? No.
Not clear from our opinion.
Yes.
It appears to be an automatic discharge without any independent application.
Sufficient opportunity was given. Ample opportunity was given to clarify.
No, sufficient opportunity what? Show cause notice.
Yeah. And
reply not accepted. No reasons given.
Yeah.
Any more? Heard Mr. P. Pathak, Learned Counsel for the petition. Also heard Mr. Igni Beku, Learned Standing, Learned CGC for the respondents. Stop. Para. The petitioner appeared in the Assam Rifles recruitment rally in the year 2009. And after undergoing physical, medical, and after going physical and medical test, he was found fit. And accordingly, he was enrolled as rifleman oblique GT in the Assam Rifles on 19/10/2009. Stop. Thereafter, the petitioner underwent the training at the Assam Rifles Training Center successfully, after which he was posted to the 7th Assam Rifles. Stop. While the petitioner was serving under the 7th Assam Rifles, there were 4 red ink entries in his service report. And thereafter, and accordingly, a show cause notice was issued to the petitioner on 15/1/2020. Stop. The petitioner replied to the show cause notice. When did you reply?
The reply is in their affidavit, my lord. Page 80. Running page 80, internal would be 52. The reply is on 14/11/2019.
On 14/11/2019. Consequent, 2019. Stop. No. No, show cause notice was issued to him, to the petitioner on 28/10/2019. To which the petitioner replied on 14/10 on
14/11/2000.
14/11/2019. Stop. The authorities by letter dated 15/1/2020 after consideration of the reply made by him, found the reply to be unsatisfactory, and a decision was taken to discharge him from service. Stop. Accordingly, by order dated 23rd May 2020, the petitioner was discharged from the 7 Assam Rifles, being an incorrigible offender with effect from 1/6/2020. Stop. Para. The respondents have filed a counter affidavit. Being aggrieved with the discharge order dated 23/5/2020. Petitioners before this court by way of the present petition. Stop. The respondents have filed counter affidavit. And in Para 2. It is stated as under, you quote 8A. Para A to A, yeah, A to A. Just marking it. Stop. Para. Learned counsel for the petitioner submits that the discharge of the petitioner due to the poor red ink entries in his service dossier was done in a mechanical manner, and the gravity of the poor red ink entries was not considered by the competent authority, while the discharge order dated dated 23rd May 2020 was issued. Now, he also submits that the Honorable Supreme Court, in the case of Virendra Kumar Dubey versus Chief of Army Staff and others, reported in 2016 to SCC 627, has held
There are 10.
that four red ink entries would not automatically mean discharge from service, and the award of four red ink entries simply pushes the individual concerned into a gray area where he can be considered for discharge. Stop. In the present case in hand, it is submitted that the four red ink entries in the service dossier of the petitioner are not serious, and therefore the impugned order dated 23/5/2020 deserves to be interfered with. Stop. Para. Mr. G. Bekulanat, CGC, appearing on behalf of the respondents, on the other hand, submits that the petitioner is serving under the 7th Assam Rifles, which is a disciplined force, and therefore the four red ink entries would automatically mean that the service of the petitioner is no more required, as he is an incorrigible offender, and accordingly, the impugned order dated 23/5/2020 was issued. Stop. He submits that the petitioner was show caused before the issuance of the impugned order, and after his reply, the order and only after consideration of his reply, The discharge order of the petitioner was issued. Stop. Para. I have considered the submissions made by the learned counsel for the parties. Stop. The four red ink entries entered into the service dossier of the petitioner has already been extracted here and above. Stop. Para. This court has also considered the advisory issued by the Ministry of Home Affairs, Government of India, Directorate General Assam Rifles, Shillong, on 15/7/2021. Stop. The relevant portion is quoted here below. B to B. The loose sheet, huh? This one. Stop. A perusal of the advisory issued by the Ministry of Home Affairs would clearly indicate that incurring four red ink entries should be examined on its own merits, depending upon the nature and gravity of the offense and the aggravating circumstances under which these offenses were committed. Stop. And the discharge from service on incurring four red ink entries is not a mechanical process. Stop. Para. On consideration of the four red ink entries awarded to the petitioner, it is seen that he underwent 3 days rigorous imprisonment for an offense of intoxication, 7 days rigorous imprisonment. No, he said 3 days rigorous imprisonment on 22/9/2017, no? For the offense of intoxication, 7 days rigorous imprisonment on 30/10/2017 for overstaying leave period, for overstaying leave granted to him, 7 days rigorous imprisonment on 5/2/2018 for an offense of overstaying leave granted to him, and 28 days rigorous imprisonment on 19/8/2019 for losing his identity card. Stop. Assuming that the first 3 red ink entries are serious in nature, this court is of the considered opinion that the fourth red ink entry is a matter which needs further consideration by the respondents. Stop. Inasmuch as the losing of the identity card may not be within the maybe beyond the control of the petitioner. Stop. In the case of New Para, in the case of Virendra Kumar Dubey, the Supreme Court has held us under. Paragraph C to C. Stop. Para. This court has also considered the communication dated 15 January 2020 by which the reply made to the by the petitioner was held to be found not satisfactory. Stop. On a consideration of the same, it appears that the communication dated 15/1/2020 was passed in a mechanical order, was passed in a mechanical manner without any consideration, without giving any due consideration to the gravity of the four red ink entries entered into the service dossier of the petitioner. Stop. Further, comma, no reasons have been recorded in the communication dated 15/1/2020 to indicate as to why the reply made by the petitioner has been found not satisfactory. Stop. Para. On a consideration of the same, this court is of the considered opinion that the discharge of the petitioner from the 7 Assam Rifles effected by the order dated 23rd May 2020 is harsh and without considering the gravity of the offenses involved in the matter. Stop. In view of the discussions made here now, the impugned order dated 23rd May 2020 is set aside and quashed. Stop. The respondents are directed to forthwith reinstate the petitioner back into service. Stop. It is also made clear that the petitioner shall not be entitled to any back wages for the period from the date of his discharge till the date he joins back to service. Stop. With the aforesaid, is accordingly allowed, no cost.
Deeply agreed.
Nineteen.
Please, your lordship, on the last occasion, they are praying for time for filing a repeat, my lord.
Standing counsel, PWD.
My lord.
Yes.
My lord, instruction will receive, but not from the concerned person, my lord. My lord, 2 weeks time may given, I will select the correct.
Date may be fixed after 2 weeks.
Mr. J. Sharma, learned counsel for the petition. On request made by M. Das,
My lord.
understanding counsel,
PW.
BW. 2 weeks further time is allowed to enable her to receive instructions. List on 20 March.
Right.
20.
Please, your lordship, my senior is engaged in another court, that's why I adjourned the matter for today, my lord.
Affidavit has been changed. Case is ready for hearing
My lordship, kindly fix the matter for admission on the next date, my present.
Okay, who's your senior?
P. Kotoki, my lordship.
On request made on behalf of Mr. P. Kotoki, learned counsel for the petitioner. List the matter after 2 weeks.
2 weeks, in the month of March, after 18 immediate month.
You want a date?
Yes, my lordship, 19, 21.
19 month. March 27. First of April.
Nothing. Yeah.
First week of April. Okay. 3rd April. 3rd. Thank you.
Obliged, my lord.
21.
May I please?
Writ
Let me
appeal
look
has
at
been disposed.
My lord, this can be disposed of, my lord. May I
No,
take
writ
your,
appeal has been disposed.
my lord,
It is pending.
it is pending, but I take your lordship to page number 57, where the earlier, in the earlier round of litigation, my lord, the ground on which the case of the petitioner has been rejected is also repeated after the, in this impugn order, my lord. That has been decided in the earlier round, page 58 is the order starts, my lord. I read, my lord, from the second paragraph. The father of the petitioner, Nakul Chandra Das, who was serving as a roller driver in the PWD Rural Road Division in the Kachar district and died in harness on 22/10/2008. And on his death, the petitioner submitted an application for compassionate appointment on 10/12/2008. It is taken note that the petitioner had a qualification of matriculation in the year 2004. The application of the petitioner was given a consideration by the DLC Kachar in its meeting of 7/8/2009, and by the resolution thereof, the petitioner was recommended for appointment on compassionate ground in a grade 3 post of section assistant. No material is available as to why the said recommendation by the DLC in the year 2009 was not placed before the SLC for its consideration. The application of the petitioner for compassionate appointment was again considered by the DLC of Kachar district in its meeting of 7/10/2021, wherein a resolution was taken that the previous recommendation of the petitioner by the DLC, apparently in the year 2009, be sent to the SLC for its consideration. Accordingly, the said recommendation was placed before the SLC in its meeting of 15/2/2022, and by the resolution thereof, the recommendation made by the DLC in favor of the petitioner was rejected by providing the petitioner to be underqualified, and also the balance of service of the deceased employee was less than 3 years. The law laid down by the Supreme Court in paragraph 25 of such and such, reported in 2027 SCC 617, provides that in respect of a compassionate appointment, the norms prevailing on the date of consideration would prevail. And from the said point of view, the reasoning given by the SLC in its meeting 15/2022 would have to be accepted to be correct. That is, on the date of consideration, the petitioner being a matriculate was not qualified for the post of grade 3 section assistant, as well as the deceased employee had less than 3 years of balance service at the time of death. But we also have to consider that the requirement of a qualification of graduation for a grade 3 post was introduced much after the recommendation of the petitioner in the year 2009. And secondly, the requirement of having balance service of 3 years was introduced by an office memorandum of the year 2015. In other words, the requirement of a balance service of 3 years came into effect on and from 2015, and it was not in existence when the recommendation was initially made in the year 2009. Had the authorities, by following the procedure of law, placed the recommendation made in the year 2009 before the SLC immediately thereafter, and the SLC would have considered the same, both the requirements of a higher qualification for a grade 3 post as well as the balance of service of 3 years would not have been in existence. But without any apparent reason, the said recommendation was not placed before the SLC at the relevant point of time when under law it was required to have been placed. In the circumstances, we have to accept that there were laches on the part of the respondent authorities itself in not placing the recommendation of the DLC dated 7/8/2009 before the SLC at the relevant point of time. In the circumstances, if we now accept the proposition that the norms existing on the date of consideration would prevail and accordingly accept the reasoning given by the SLC, we would accept a situation where the respondents would be allowed to arrive at an advantageous situation when there were laches on the part of the authority itself. Such approach would be contrary to the legal principle that no one can take advantage of his own laches and claim for an advantageous position. Considering the said legal principle, we interfere with the rejection by the SLC in its meeting dated 15 to 2022 and remand the matter back to the SLC for a fresh consideration and place the same before the next available SLC by taking note of the observations made herein above. Thereafter, on the same ground, they have rejected at page number 64, my lord. Therefore,
Page
64, serial number 8. Earlier it was 2 ground, now it is 1 ground. Less than 3 years balance service at the time of death. Therefore, obviously, this is not sustainable in the eyes of law, my lord, as per the direction and the settled position of this judgment, my lord, given in this judgment, my lord. Therefore, whether the writ appeal is pending, my lord, will not come into effect.
Why not?
Because when this order was passed, my lord, on that day, the condition was prevailing, 3 years of less service. That even then, my lord, this honorable court explained and given the reasons for interfering with the conditions, my lord, imposed.
After this court has passed the order.
Yes.
SLC said again.
Yes, and the same
they
order is passed.
rejected the
Same.
order.
They have not considered.
They considered the matter.
They have considered, my lord, and the same ground where this honorable court has explained while interfering with
Because
the.
at the prevailing time, when the SLC considered your matter,
Yes.
that notification was in force.
Yes.
Thereafter, by order passed by this court, that particular paragraph was set aside. That has gone before the division bench, which is under stay.
Yes, lordship, but
Then what can we do now?
but my lord, I take your lordship, but this honorable the single judge in the WPC number 1646/2021 decided on 31/2023, and this order was passed on 21/4/2022, my lord, itself. That is before the when it was in existence. At that time, this honorable court has passed this order, my lord, in respect of the petition. Therefore, your lordship can dispose of in the same line, my lord.
Going by the case of NC Sandosh.
Yes. NC Santosh let me explain that
SLC
it
has
is
to consider as per the prevailing norms.
that will not.
Prevailing at the particular, at that point of time.
Yes.
So that time that notification was there.
Yes,
So
this
the-
honorable court filed.
So the SLC did not go against NC Santosh case.
Yes.
It
But
went according to the directions passed by the Supreme Court in NC Santosh case.
Yes.
Correct. Now the issue is that the SLC has considered your matter.
Yes.
You have to await the outcome of the writ petition, writ appeal. After that only we can decide now, this part.
Writ appeal, well, there is no stay order, my lord.
There is stay order. There is a stay order.
Earlier it was no stay order.
Though earlier there was no stay, later on there was a stay order.
But the decision of this honorable court is dated, my lord, 21/4/2022. When I read, my lord, that shows, my lord, on
No,
the day of.
that point of time, court took a different view.
Yes.
Because if they had not delayed, then maybe you could have been considered by the SLC.
And the court also.
After that, SLC considered.
After that, SLC considered, my lord, while considering what they have done, my lord, they have not taken into consideration the principles laid down in this order, my lord. That is the grievance, my lord. They have
So
not.
there are two conflicting things.
Yeah.
NC Santosh case, when SLC considered NC Santosh case was there.
That is there. That is there.
So
And that will not come into.
That case provides that it has to be considered as per the prevailing situation.
That will not come, my lord. I place
That will come.
in this regard, I place another judgment of the Honorable Supreme Court, my lord.
No, anyway, let us wait for the outcome of the writ appeal.
By this time, my lord, some more times time will be lapsed, my lord.
Maybe it will be over soon. Let us.
Another judgment is there, my lord, which will support my case, my lord, from the Supreme Court.
Okay, what Mr. A.K. Purgayasal and the counsel for the petition. No, P. Purgayasal.
We will.
Mr. J.K. Barajuli, Learned Governor Advocate submits that the matter involved in the present petition is pending before the Honorable Division Bench in writ appeal 287 of 2023. So, accordingly, list this matter after 4 weeks.
Any fixed date will be given, my lord, so that.
List this matter on 1st of April.
Problem.
Indulgence, my lord. Item number 43. Item number 43. Contempt matter, this has become infractions, my lord. Order complied.
Comply, my lord.
Point is there, my lord. It can be closed.
Your good name?
Dismissal, my lord.
MS Dismissal and a counsel for petition submits that the respondents have complied with the order passed by this court. Mr. Hardhar.
So 1, 2, and 4, my lord.
Appears for 1, 2, and 4, and MS
G. Swami for respondent number 5
and G. Swami for
on behalf of Mr. A. Sharma.
accordingly. Contempt petition is closed.
Deeply approved, my lord.
Oof.
22.
Get it back for.
May it please, your lordship. My lord, in this matter, we require the Sexual Harassment of Women at Workplace and Prevention or Prohibition of Dismissal Act 2013. It's in this campus. This entire petition is fine. Briefly stated, my lord, page 33 is an allegation of sexual harassment against me by a fellow colleague of mine, a lady.
Page
33. May I read that?
Yes.
Sir, I'm so-and-so working as JE Commercial at RHQ NER Guwahati since January 17. I'm writing this complaint letter to bring to your notice the incidences of sexual harassment that I've been facing at my workplace for the past few months in the hands of Mr. Praveen VS, who's me, my lord, who is my reporting officer and DGM Commercial in a commercial directorate RHQ NER. Mr. Praveen VS has been trying to make inappropriate physical contacts during official hours. I've also been receiving obscene images and videos of Mr. Praveen VS through WhatsApp. I have been ignoring such messages, though I found it inappropriate to receive such messages from a senior male colleague. A similar incident happened again on the 24th of January 2020 at around 6:15 p.m. when he tried to make physical contact inappropriately by holding my shoulders and kissing my cheeks before leaving office. This incident has greatly affected my mental state, forcing me to report the situation to the RAD-NER. This letter is no act of vengeance from my part, but only to safeguard my dignity and mental peace, as this whole incident has made me extremely frightful and havoc my mental peace. Therefore, to maintain tranquility in workplace, I request you to kindly take necessary action against him and transfer me away from him. Well, not so far, so good. Some lady had some grievance ventilated within the scheme of the act. Now, once such a complaint is lodged, the act comes into play. Because this is not under IPC, Miller. We are coming in the Sexual Harassment Act. Once a complaint is lodged, this act at section 9 may I read, Miller? Any aggrieved woman may make in writing a complaint of sexual harassment at workplace to the internal committee if so constituted, or the local committee in case it is not so constituted, within a period of 3 months from the date of incident, and in case of series of incidents within a period of 3 months from the last date of last incident, provided that where such complaint cannot be made in writing, the presiding officer or member of the internal committee or the chairperson or the member of the local committee, as the case may be, shall render all reasonable assistance to the woman for making the complaint in writing. Provided further that the internal committee, or as the case may be, the local committee, may, for the reasons to be recorded in writing, extend the time limit not exceeding 3 months if it is satisfied that the circumstances were such which prevented the woman from filing the complaint within the said period.
where the aggrieved woman is unable to make the complaint on account of a physical or mental incapacity or death or otherwise, a legal heir or such other person may be prescribed, may make a complaint under this section. My lord, this deals with logic of the complaint, time frame, extension. Even if someone dies, someone else may come in. Section 10, the next step. It's an if, then, else sequence, my lord. Once the complaint is lodged, section 10 is invoked. The internal committee, or as the case may be the local committee, may, before initiating an inquiry under section 11, at the request of the aggrieved woman, take steps to settle the matter between her and the respondent through conciliation, provided that no monetary settlement shall be made as a basis of the conciliation. Where the settlement has been arrived at under subsection 1, the internal committee or the local committee, as the case may be, shall record the settlement so arrived and forward the same to the employer. This is important matter, to the employer or the district officer to take action as specified in the recommendation. Where the settlement is arrived at in subsection 1, no further inquiry shall be conducted by the internal committee or the local committee as the case may be.
Where is that?
The 4, 10-4, subsection 4. Where the settlement is arrived at under subsection 1, no further inquiry shall be inquired by the internal committee or local committee as the case may be. Meaning thereby, if under section 10, prior to going for the inquiry, a conciliation is reached and a settlement is reached, the matter ends there. What happens if it is not reached? Section 11. Subject to the provisions of section 10, the internal committee or the local committee, as the case may be, shall, where the respondent is an employee, proceed to make an inquiry in the complaint in accordance with the provisions of the service rules applicable to the respondent, and where no service such rules exist, in the manner as may be prescribed, or in case of a domestic worker, the local committee, if prima facie case exists, forward the complaint to the police within a period of 7 days for registering the case up to section 509 IPC and any other relevant provisions of the code when applicable. May I pause for a moment? This 11 springs up if in 10 there is no conciliation, no settlement reached. Then 11 comes up. So if 11 comes up, no conciliation reached, no settlement reached, and if I am an employee, it goes to my employer to take up the DP in accordance with service rules. That's how the scheme. Provided that where the aggrieved woman informs the internal committee or the local committee, as the case may be, that any term or condition of the settlement arrived in the subsection 2 of section 10 has not been complied with by the respondent, the internal committee or the local committee shall proceed to make an inquiry into the complaint, or as the case may be, forward the complaint to the police. Now, if I say something and I do not adhere or respect it, and she's aggrieved, well, the first part comes in. Secondly, provided that where both the parties are employees, in our case, the parties shall, during the course of inquiry, be given an opportunity of being heard, and a copy of the findings shall be made available to both the parties, enabling them to make representation against the findings of the committee. Notwithstanding anything contained in section 509 of the Indian Penal Code, the court may, when the respondent is convicted of the offence, order payment of such sums. But we leave it for that. That was post-conviction. Well, our case ended in section 10. Conciliation settlement. Page 34 of the writ petition. 9, 10, 11. 9, the complaint was lodged at 33. 10 at 34. May I read me? In accordance to the written complaint submitted by so-and-so, dated 29/1/2020, second meeting of the so-and-so was held today on 30/9/2020 in the office of the GM Engineering Electrical NER, where the first meeting was held on 15/9/2020. We have arrived in a conclusion today itself during the proceeding of the meeting to conciliate the matter that we both, forgetting all the past bitterness, shall maintain a good official relationship to each other, and that no such situation may arise in future. It is hereby declared that no further follow-ups shall be made in this matter from our side. On the left is me, on the right is the lady. This is section 10. Now it enjoins upon the inquiry committee to record. That would not go further because of this. This comes, my lord, at page 39, the inquiry report. 39, the inquiry report.
Yes.
I will not trouble you, Lordship, much because you already know. Page 42, the first part. Page 42, the first part. After the talk, may I read? After the talk, they told me, they means four of us, to the committee that the matter has been discussed and they reached to an understanding and ready to give a joint statement to the committee for the reconciliation. The committee asked Miss So-and-so to confirm, and she reconfirmed that she's also ready for reconciliation and for a joint statement that they both forgot all the past reported events and shall maintain a good official relationship to each other, and that no such situation may arise in future and no further follow-up shall be made on the complaint. They submitted the joint statement to the committee. This is what the inquiry report says. Eventually, in the observations below, may I read the second paragraph? The committee further asked Ms. So-and-so that what is her expectation from the committee. She reiterated that her intention was not to get punishment to anybody, only to ensure a comfortable office environment, and requested not to post both of them in the same office. That's bold and italics below. Committee explained to her that the committee is not empowered to make a commitment in this matter, and even Airports Authority of India management may be helpless as both of them are in the same department with less officers and both are having long service further ahead. Committee told her that, however, her request will be reflected in the report. This is how the committee proceeds. The conciliation, the stand, and the observation in detail. The conclusion at page 43. The summary of what has been written, 43. No conclusion could be made regarding the complaint dated so-and-so due to lack of evidence proof witness. Shri Praveen totally denied the incident. The complainant and the petitioner wanted the reconciliation and they don't want the complaint to be followed up further. Hence, the request for reconciliation is forwarded for acceptance. The committee would like to bring to the notice of the concerned authority the request of Ms. So-and-so not to post them in the same office. Following that, so complaint was there, reconciliation was there, both adults, male, female, consentingly, we say, let's forget the matter. We'll not take it up further. So section 10 invoked. Section 10 invoked, the inquiry report says, okay, things are over. Now at page 44, the next page. The General Manager HR, may I read that? In this context, it is intimated that on the basis of the aforementioned complaint under section 9 of the so-and-so, Internal Complaints Committee, NER, conducted an inquiry and submitted its report to Disciplinary Authority on 9/11/2020. The committee in its report has concluded that the main allegations against the Praveen VS Asmi DGM Commercial could not be substantiated due to lack of evidence. Further, the respondent and the complainant have jointly discussed the matter in presence of the committee members and come to an understanding that they would go for conciliation and not pursue the matter. On perusal of the report dated 9/11/2020, Disciplinary Authority has decided that the conciliation between the complainant and the accused in terms of their joint statement under section 10 of the Act of 2013 be accepted, and therefore said complaint be treated as closed. It was everything, right from the complaint, the conciliation, the report, and the acting on it to be closed is accordance with law. Point is anyone aggrieved by it? It's a conciliation proceeding. End of the matter. Page 39 started, the difficulty started, which page 45, sorry, the next page. When the lady, after around a year or so, again wrote, again, may I read what she wrote? This has reference to letter number so-and-so, Ms. So-and-so. With regard to the above mentioned letter, I, as a complainant, would like to inform you that there was no lack of evidence from my end. In fact, in my earlier complaint dated 29/1/2020, addressed to the Regional Executive Director, I've clearly mentioned about receiving some obscene images and videos from Praveen VS. The committee member did not ask me to produce my evidence, but insisted that I have a one-on-one conversation with Praveen VS as requested by Praveen VS and close the matter. Even after the hearings from both parties, the matter remained inconclusive, and therefore I agreed to have one-on-one conversation with Praveen VS to conciliate the matter, as it was taking a toll on my mental peace. Therefore, to conclude that, quote, the case could not be substantiated due to lack of evidence, unquote, is false and biased statement. I'm hereby forwarding the screenshots of the WhatsApp chats and images that I've received from Praveen VS, so it is requested to take necessary action to modify, I repeat, I reiterate, with your lordship permission, to modify the statement for clothing the same. My lord, it's also requested I may never be put to work under Praveen in the future, despite necessary action. All she requested was that we'll conciliate it fine, no difficulty, but don't put the word that there is no evidence. Just modify that part. On this, page 46, a closed proceeding was reopened. A closed proceeding was reopened. This is reference to complaint dated so-and-so, filed by so-and-so, along with the screenshots. This was no complaint, only a modification was sought. Accordingly, proceedings were fixed on so-and-so where VS Praveen appeared before the committee and requested for copy of complaint along with attachment of filing reply. Accordingly, find attached copy of the complaint so-and-so, subject so-and-so. It is requested to file your reply on the complaints dated so-and-so and its attachment screenshots. I wrote a reply at page 47 detailing that the matter was closed in accordance with law, and all she insisted was the modification of the conclusion and no more. But taking a cue from here, what the authorities did was at page 22, annexure A, they initiated disciplinary proceeding against me.
Page
22. This is the undersigned proposes to hold inquiry against Praveen VS while functioning as Deputy General Manager under Regulation 29 of AAI so-and-so 2003. The substance of imputation, both are there. I'll refer to article of charge at next page. That will be convenient, below. May I read? Article of charge 1. Shri Praveen VS, while working as Deputy General Manager Commercial RHQNER, Guwahati, presently posted at Patna Airport, displayed inappropriate behavior with the complainant and tried to make physical contact inappropriately on 24/1/2020 at around 6:15 p.m. when she was sitting in the office room in the Commercial Directorate RHQNER, Guwahati, and waiting for a driver to come. By the above act, Shri Praveen VS so-and-so created intimidating and hostile working environment for the concerned female employee. 2. Shri Praveen VS, while working as duty so-and-so, sent inappropriate and extremely obscene text messages and images to WhatsApp from mobile number so-and-so, so-and-so. By the acts, he acted in a manner which is unbecoming of him as an employee of the authority and failed to conduct himself soberly and temporarily while on official premises. He acted in a manner which is prejudicial to the interest of AAI and indulged in act of sexual harassment of women in workplace, so-and-so, so-and-so. My lordships, these were the facts in the complaint. And once the complaint came, the act sprung into action. The inquiry committee was there. I participated. She participated. A conciliation was reached that we settled the matter. The inquiry report was forwarded. The matter be closed. There is no way the department could have initiated the proceeding against me. It's barred by law. Number 1. Number 2, assuming but not admitting the lady had raised a grievance, that grievance must come within the ambit of that me violating any statement or promise of mine within the conciliation thing when a request was made. That was not so. All she said was, look here, kindly modify to the extent that there were evidence and no more. Well, an additional affidavit has been filed by me. That would be, it's there on record. Additional affidavit has been filed. That's sometime in the month of August 23. I said,
yes.
May I invite members' attention to the annexure, Miller? Oh, there's only one annex. May I read that? That's on November 5th or 10th, 2014. Airports Authority of India introduced its policy on prevention and redressal of grievances relating to sexual harassment at workplace wide corporate administration, circular number 9/10 dated 26/8/10. The government of India, however, notified the act as Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 in the Official Gazette of India on 23/4/13, and also notified the rules under the said act as Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Rules 2013 by its notification dated 9/12/13, which are applicable across the board. Provisions of the new Rules Act supersedes the AAI policy circulated by Corporate Administration 910 dated 26/10/8/10, and the case reports should be processed accordingly. So, initially, the Airports Authority of India had the set of rules in case of sexual harassment go on the workplace. Now, once the act comes into force, they adopted the act, had to. And therefore, they had no jurisdiction, save and except 10 fails, and in 11, it is reported to them. Then they can take up the matter. That is my case. There's an interim order protecting me after a detailed discussion of the submissions and the materials on record. Pausing for a moment, if I may submit today. The lady is here. The authorities are there. I am here. What are we basically on? We're basically on.
The departmental inquiry is proceeding or?
It has been stayed by this honorable court, my lord. It has been stayed.
By
Because,
which order?
my lord, the first order, that would be 20th of February, my lord, 2023. No, it doesn't. 24th of February. 24th of February, my lord.
That was
First day.
considerable day.
Continue. But that is in paragraph 9 would be relevant, you know. May I read paragraph 9, my lord?
I've read.
My lord. Mr. Dove was there, paragraph 10. There is no such recommendation. They admitted the fact. They admitted the fact. And now this circular comes which says the act holds the field. There is no recommendation. Conciliation on record. Even the lady admits it, that's a conciliation. Only thing she requires a modification. I understand, my lord. We live in a society where it's natural. It's natural to have that feeling. Being an officer of the court, I say, it's natural to have that feeling. Of course, she might have submitted herself to the conciliation proceeding and the matter might have peacefully been ended. But some words may hit for life. It is possible. To that extent, they may modify. I don't have a problem with that. But the act and the consequences of a proceeding under the act, that has to be followed. That must be the rule of the law. They can't do it otherwise. And the department has no jurisdiction under the law, under any law whatsoever, to initiate a proceeding against me. And that too, on the issues covered under the act, proceeded in procedure of the act and then followed. That's all we know. Proceedings are stayed. No, they cannot torture me on that. They could have under the act if there was a recommendation, but there is no recommendation. My friend was fair enough to submit that on record. Let the matter be closed. Let the authorities take a call as to whether they would like to modify or not. That will be fair. That would be fair. I should not be put to peril. This one is holding your mission affidavit. It's binding on it.
My friend is relying upon this circular of ours, my lord.
There's no counter to it. Even if there was a counter, the law was there, holding the field. And there is no denial to that conciliation. There is no denial that there was no recommendation. It's a suo motu, ab initio, unilateral, divorce the law proceeding, my lord.
But subject to what your lordship says, but this is case quite in the background of a unique factual situation. But and lordship, perhaps my learned friend has taken a lot of the facts of the case. But when, my lord, the authority saw, my lord, that the proceedings have been closed, and, my lord, the private respondent is aggrieved by that, my lord, a representation was, my lord, given to us
And after considering, my lord, the authority thought it proper that there has to be a departmental proceedings, because my lord, the lordship would see the nature of the allegation. It has ramifications, my lord, on the work culture of the authority. And therefore, my lord, we took a decision that the proceeding should be initiated. That's how, my lord, the show cause notices was issued to the petitioner, my lord. Your lordship find, my lord, which has been annexed in the writ petition. And this was on the basis of the complaint that has been filed by the private respondent. And we have also filed our affidavit, my lord, and my lord, we have indicated that our decision,
Where's your affidavit?
my lord, will see page start at 96.
Hmm?
Page 90, continuous page 96, my lord. Has your lordship got, my lord?
No.
It was filed by one Alithia Doron Lalu, Assistant General Manager. अच्छा. Paragraphs 4, 5, 6 of my affidavit, your lordship.
Yes.
In para 5, we have stated, my lord, how this, with regard to the same, the same is admitted to the extent that disciplinary authority accepted the finding of the complaint committee on so and so and letter of closure issued on. But in this regard, it is stated that the present disciplinary proceedings have been initiated by the disciplinary authority after having taken into consideration the representation dated 25 to 2001 of the complainant, whereby she disagreed, agreed with the conclusion rendered by the ICC that the case could not be substantiated due to lack of evidences, as well as the production submission of documentary evidence by the way of the screenshots of messages sent by the accused petitioner. With regard to the statement, the answering respondent deny the correctness of the statement made in paragraph 1 beg to state and submit. The complainant by letter dated submitted her grievance on the infirmity of the proceedings of ICC and conclusion of inquiry report that the case could not be substantiated due to lack of evidence without asking her to produce any evidence at the time of hearing. Whereas in her complaint dated so and so, she specifically mentioned about receiving so and so from so and so. She further submitted that the committee insisted her to have one-to-one conversation with so and so and close the matter. However, after various hearings, the matter remained inconclusive. Therefore, she agreed to have one-to-one conversation with so and so to reconcile the matter, as it was taking a toll on her mental peace. The complainant had disagreed with the findings of the ICC to the effect that the case could not be substantiated due to lack of evidence. The complainant also endorsed screenshots of WhatsApp chats and messages sent to her by so and so, and further requested to take necessary action to modify the closing statement of the case and not to post them together in future.
That I've considered.
My lord, basically it was an independent exercise done by us, my lord, to initiate departmental proceedings on the basis of the
But
complaint.
then conciliation took place.
Yes, yes, that
Yes,
took
yes.
place.
So matter was closed.
Closed.
Matter was closed. But she raised a grievance, my lord,
25 to 2021 letter your lordship has seen. And basis of that letter, my lord, the authority thought it proper that the proceeding should be initiated against the.
What did she say in the letter?
To modify the statement for closing the case, page 45 of the writ petition. Quote unquote. The initiation of proceeding is absolutely against the law. Ex facie is bad in law. If I'm permitted, my lord.
Appears not from the letter that her major grievance was that the finding of the committee to the effect that the case could not be substantiated due to lack of evidence. So that observation was against.
Page 45.
My lord will also see section 14, my lord.
This is a different thing.
There's a different thing.
Perhaps that might also might have vague, my lord. But anyway, my lord, since
This is with regard to the complainant.
complainant, my lord,
Complainant makes something false allegations.
my lord.
Then this is what happens to the complainant.
So that observation may be also linked to that also, my lord. Because if the committee says.
If the complainant makes some false allegation,
Yes.
why should you have a departmental proceeding against the
No,
petitioner?
no, Lord. Lord, the conclusion of the ICC, Lord, if they say it's due to lack of evidence
What does she say in the letter
To modify
to modify, my lord.
the statement for
That's all.
closing the case.
for closing the matter?
You close the
all
matter.
that the
change-
observations made in the internal complaints committee,
My lord.
she just said, no, this is not correct.
Yes, yes,
No, no, no.
You
not that
either
part.
modify it
my lord.
and close the issue.
Only the conclusion part, not the observation part.
Yeah,
The
that's why.
conclusion
The
part.
conclusion part.
Only the conclusion part. The observations are correct. Stands by that. No conclusion could be made regarding the complaint it is so and so due to lack of evidence, proof, witness. She Praveen totally denied the incident. She says that there was incident. And the mediation part, the conclusion part, this is agreed. There's no difficulty with that. Even otherwise, they have no right to reopen.
Perhaps my friend representing the private respondents, my lord, can throw further light on that. But so far as we are concerned, my lord, we have gone by her letter, and based on
Where's
this,
the conclusion?
Conclusion may not finds at page 43.
lordship would see the observation as page 42.
That is.
Observation is not touched. The conclusion, lack of evidence, that's touched. Anyways, that does not obliterate the conclusion proceedings and the conclusion reached, the settlement arrived. Madam, if I may submit to that extent, that the lady is confined to the communication at 25/2/2021, whatever she said, that would not be elaborated by a oral submission or affidavits. We strict to that, stricto sensu, that's what the lady meant, literal rule applied. Literally, we understand that. We don't need to emphasize on what she said. I am not even on what she said. I am on the department. I'm not against the lady. She asked something reasonable. A woman would ask. She didn't ask for the heaven. She asked something reasonable. But the departments initiated action against me, the power which they do not have, because Rule 11 categorically says when the authorities would initiate proceeding, and it's not the department, it's the Internal Complaints Committee who had the power. 11, Subject to the provisions of Section 10, the internal committee or the local committee, as the case may be, shall, where the respondent is an employee, proceed to make an inquiry into the complaint in accordance with the provisions of the service rules applicable. Therefore, if the conciliation is not reached, it's the committee which proceeds under the service rules. The department still did not have the power. And subject to provisions of section 10. Once section 10 is reached, 10 subsection 4, where a settlement is arrived in a subsection 1, no further inquiry shall be conducted by the internal committee or local committee, as the case may be. If settlement is not reached, proceed under departmental rules. And by this, the Airports Authority of India have adopted the act. They had to adopt the act. It supersedes all their rules and regulations, whatever they have on this sexual harassment issues at workplace. They cannot appropriate and reprobate me. No, they have to take a stand. They are on this by record. This is their stand. I'm not against the lady for a moment, Milord. What I'm on is that there did not be any elaboration of what she thought or meant. Whether they could initiate a proceeding against me. On the face of it, it's bad in law.
How it culminated, my lord, will see paragraph 8 for a moment. That we have placed before your lordship, Lord, how it happened. Now your lordship has to decide, Lord, whether we are right or wrong, Lord. What in our fair understanding, what we considered it to be that, Lord, we have done it. Para 8, Lord, page 101. That with regard to the statements made in para 12 of the writ petition, the answering respondents do not admit anything which is borne out from the record of the case, and stated, as per representation dated so and so of the claimant, to modify the concluding statement, the matter was referred back to the ICC, NER, to review and revisit the report in light of material provided by the complainant. In response, the ICC, by letter dated so and so, submitted the following clarification. We'd like to state that the complaint was disposed of on mutual consent between the parties, as both the parties had agreed mutually and submitted joint statement to the committee to settle their dispute. The narrations of the mutual consent joint statement be highlighted as, we arrived in a conclusion today itself during the proceeding of meeting to conciliate the matter, that we both, forgetting all the past bitterness, shall maintain a good official relationship to each other, and that no such situation may arise in future. It is hereby declared that no further follow-up shall be made in this matter from our side. Therefore, there was no need to go for further proceedings, as the matter closed based on mutual consent joint statement submitted to the committee. This is the contents of the letter dated 5/5/2020 we have highlighted, but because we have placed this matter before the same ICC, which says that no, we cannot do anything. Later on, ICC proceedings were considered as closed, and subsequently major penalty proceedings were initiated against the petitioner by memo number 12.
This was bad in law. The initiation of proceedings.
That is how this is our decision-making process, my lord. We have gone through.
And I pray the matter be referred to the committee to exercise discretion as to whether or not they would like to modify or not that closing statement. I do not know whether they have the power of review. I believe they do not have. But still, considering it's a lady, it would be a case of hard running further. Let them consider whether they would like to modify or not without touching upon the conciliation reached, the settlement arrived, and the initiation of proceedings by them. There's no question of inquiry or de novo inquiry. It's without any support of law. There's no thing they can lend their credence on, my lord. There's no law to justify it. We're a very strict campus. Sexual harassment. You cannot go outside, my lord.
Yeah. Okay.
Well,
but he was fair. On the first day, he made that submission that yes, that order is there.
That I've seen.
And that is there. He was fair enough.
On the legal aspect,
He's fair.
Question is there, but we have gone into in the peculiar facts and circumstances.
What peculiar facts and circumstances? What peculiar facts and circumstances? All she wanted was a modification of the observations, the conclusion, where they said that there was
Yes.
no
evidence.
No evidence.
Para 8, your lordship has seen. We have in fact referred the matter to ICC also, my lord.
Where is that letter? Where is that letter?
Letter is not, we have indicated the contents of the letter, my lord.
Where is that letter? Let us.
But they have not annexed that.
That letter we have not.
Anyways, my lord.
Let us see.
But I can show you, my lord. Today that letter is not there.
I may say, regardless of that, their sending of letter was also maybe a part of the discretion. I'm not on that. Discretion can be good or bad. But initiation of proceedings, my lord, lordship has heard the matter at length. Nothing more remains.
Anyway, you have a stay order in your favor.
Yes, but my promotional aspects are being stalled. I cannot move. If lordship made one observation that stay order remains on the proceeding, my promotion be considered. Then I am safe. Otherwise, everything is stalled by an act. The lady cannot have an objection to that.
Yes, who appears for the complainant?
And it's on for respondent number 2, your lordship.
Respondent number?
Seven.
Seven.
The lady. After hearing my learned counsel, lordship, basically conciliation, this entire sexual harassment for women, the POSH Act as it is called, basically when a complaint is initiated over there, the committee, there's a time frame which is involved and it is a conciliation process. Lordship very well knows that conciliation is a type of an ADR process. So when we talk about ADR, it's an absolutely informal process, but in this particular act, it is specifically mentioned that it has to be initiated by the aggrieved woman. If you could kindly go through the section 10 of the act. Section 10, may I read? The internal committee, or the case may be, the local committee may, before initiating an inquiry under section 11, and at the request of the aggrieved woman, take steps to settle the matter between her and the respondent through conciliation. If we go into the reports which have been sent and the summary of the proceedings which have been sent, Lordship will also refer to my paragraph in my IA, and I have filed an IA also, and in my affidavit opposition, which I will take you through, your Lordship.
What is the IA for?
IA is for vacating the stay order, your Lordship. Because what has happened now in this act is a very woman-specific, gender
No,
specific.
that's fine. That's fine. We understand the
Yes, sir.
aims and objectives of the act.
Everything. Now,
The issue is this.
yes, sir.
There was a conciliation. May have been initiated by the petitioner, may have been initiated by the complainant.
Yes.
In this case, I'm not talking about the act. In the act, it says complainant has
She
to.
has to initiate and she has to give a consent.
But in this case, maybe petitioner has initiated or you may have initiated, but there was a conciliation.
Okay, yes, sir.
Fine.
Yes.
Conciliation, everything ended well. Observations were made and conclusions were drawn up. Correct. Thereafter, you made a letter. You wrote a letter saying that the part in the observation, in the conclusion, is not correct. So you please modify to close the matter. That's the language used. Modify to close the issue. It's only for modification of the conclusion.
Yes, Your Lord.
What do you say on that?
Now, my thing now, Lordship, what I would like to humbly submit is, at that point of time, it was only a matter which was in the office. Very few people knew about it. So when they closed the thing, it was when they conciliated and they closed the matter totally, it was he, me, and the ICC knew about it. So it was, but it was a very personal thing because the act mandates that it should not be publicized. Her name should not be, made known. Even in our cause list, it should have been anonymized actually, but her name is being reflected. So now where 3 people or 6 people or 7 people knew about it, now the entire office and every other office knows in the AI, everybody knows about this case. My name is also splashed. So at that point of time, I said, all right, if they modify it. But now they're insisting because while even the time frame, if I may humbly submit, the time frame, there's a very important time frame which has been specified by this particular act, which was not even adhered to. So right through, she was getting this feeling that she was being, her complaint was not being taken seriously. So even during the conciliation process, they were dilly-dallying. She did specifically say, in fact, in her statement also, I have video chats and all enough evidence. In spite of that, the committee said, the ICC said that no. So this is what I am humbly submitting, that the entire procedure of conciliation was not proper. You send me for
But
conciliation.
you accepted the conciliation.
I did because he's my senior, your Lordship. He's my senior and he's still my senior. And when I asked her,
we have to go on the basis of records.
I absolutely agree with
On
you,
the
your
basis
Lordship.
of records.
I absolutely agree with your Lordship. But the fact is now that the proceedings have started. The conclusion of the proceedings is not there, your
It
Lordship.
is not the case.
Yeah.
It is not the case that this court has no sentiments towards the complaint. That is not the issue. In such matters, always the first thing the court is, they have a sentimental this thing towards the complainant. But here, see, like I said earlier, conciliation may have been initiated by 80 of the
That's okay,
parties.
all right.
Maybe against the act. Maybe against the act.
Yeah.
But then there was a conciliation. You put your signature there. It went to the ICC. Correct. The matter ended there. What wrecked up the issue was because of the conclusion made by the ICC.
Yes.
So you said, no, that conclusion is not correct.
And even for observation, Your Lordship.
No,
The
No,
observation
no,
number 4 also is wrong, Your
no,
Lordship. In the conclusion,
In the conclusion,
it is based on the observation number 4 also, which he talks about, this. Now, Lordship, just assuming that she is the woman, she has gone, she's filed a complaint, and the complaint, she said, all right, we'll forget this, that, for whatever reasons, all right. Now, the thing has come out, it is flashed everywhere, oh, they have closed the complaint because she had no evidence. So it is a lie. The entire case is a lie.
then you could have taken recourse to section 14.
Section 4, no, that means I have lied.
Exactly, that's what you're trying to say.
Then I would have had to.
That is not the issue here.
not the issue.
No, that's not the issue here. But the thing is that
ICC
the woman is now in a position where everybody in her office, she's in a position like that, Your Lordship. So she had no other way, but she wrote that letter saying that, this, I want this modified.
Correct.
But then they did send back the letter to the ICC for modification. But there is no provision which says that they can modify a particular inquiry report. The ICC does not, there is no provision in this act which allows the ICC to modify any inquiry report. Actually, this should have been it should not have gone up as an inquiry report, Your Lordship. It should have gone up as a conciliation agreement settlement. Because an inquiry report goes up when section 11 comes in. We stopped at 10. So 10 say it should have gone up as a conciliation agreement. And if it had gone into 11, where an inquiry had set in, and then an inquiry report had gone up, then there would be, otherwise it should have simply gone up as, because this is like a mediation, it's like a conciliation, where you do not put any aspersions on anybody. It is that both the parties have come to an agreement. This is the agreement, and the matter may be closed in view of the agreement. Not that no evidence is there, no this is there, not there. So
That
she has
part-
taken it like this.
That part,
Yes,
this court also agrees with you that the ICC had committed a mistake
yes, Your Lordship.
by
Absolutely.
making that
Absolutely.
observation
Yes, absolutely.
in the conclusion.
Yes.
All they could have said was there was a conciliation between
And
parties.
matters settled between them.
Matters settled, you could have kept quiet.
Yes, absolutely, absolutely. Your Lordship is absolutely correct.
But
Now,
because of that
yes, Your
conclusion,
Lordship.
you wrote this letter
Yes, Your Lordship.
saying, please change it
Yes,
and then close the matter.
and close the matter. But in the process, Your Lordship, what happened was so many more people got to know about this incident. It was a very private, this is just a small incident in our
That I
office.
understand.
And then her name, a lot of people. So now she's, now she, oops, it's come. They have not, the disciplinary authority has not come to a conclusion. They have only initiated it. Maybe there also they will say, okay, this is what her stand was. We will close it. That also can still be the outcome of this disciplinary proceeding. It can still be the outcome, Your Lordship. When now that if they continue this proceeding, because there is no other option, how do they delete that particular word? It has to come back to the disciplinary authority. When it comes back to them, she can put the same things can be placed before the disciplinary authority and say that this is what has happened. She only wants that. They can do it because there is no provision in the act for the ICC to do something like that. So who deletes that particular comment? Assuming that yes, I want only that particular comment deleted. So who does it, Your Lordship? Who will do it? The disciplinary authority. They can put absolutely the same case before the disciplinary
Can the
authority.
disciplinary authority tinker with the conclusions made by the ICC? Cannot.
But they can take it into consideration, Your Lordship. They can. Because this is not. But then what happens to the ICC report then, Your Lordship?
This is the.
Well,
That is the problem. Your
in all
Lordship.
fairness, how it can be closed, may I submit, Mila? How it can be closed? If I want to file the writ petition, it has to go to a particular bench 2, 3, 4. I cannot have it in a criminal bench. Similarly, once an act has been gone into invoked, The provisions of the act has to be adhered to, whatever it is. The question is, she is not the writ petitioner saying that the authorities have not done this or not done that. I am the writ petitioner challenging an action, that initiation of DP against me, saying it is not based on law. No credence can be given to it. So that is between me and the department. Whenever her turn comes in the departmental proceeding, if it subsists, fair enough, have your stand. But so far as your conciliation is concerned, that is in the finality. Page 35. That's more interesting.
Continue with the, that's what I'm saying.
Page 35. DP cannot continue. When initiation is bad in law. The very initiation is bad in law. Page 35. The hard binding can't go too far, Milo. It has to be within the precincts of the act. Third para, the committee called, Lordship has got towards the end. The committee called Miss So-and-so and asked her for her opinion. She expressed that she is ready for one-to-one discussion with him. As so-and-so agreed for one-on-one talk, the chairperson of the committee discussed the matter with the members that whether the same can be permitted as the matter is with the committee. The external member of the committee, who is a senior practicing advocate, confirmed that as per the legal practice permitted under surveillance of the committee. The committee gave consent for one-to-one talk of 5 minutes in the same chambers where the proceeding is being conducted under surveillance of the committee. After the talk, he told the committee that the matter has been settled and they reach an understanding. They're ready to give a joint statement of the committee. The committee asked Ms. So-and-so to confirm, and she reconfirmed that she's also ready for reconciliation and for a joint statement. The joint statement states that they both forgot all the past report events and shall maintain a good official relationship to each other, and that no such situation may arise in future, and no further follow-up shall be made on the complaint. That's all, my lord. You know, being a male child is difficult. Even in marriage, 7 years, the wife dies difficult. Some dowry demands difficult. In workplace, someone gives a complaint, conciliates, back comes in court and says, no, initiate the DP. Difficult. We'll face, as gentlemen, we'll face it, my lord. If I've done something wrong, now let's take him to the extreme. We shared obscene things across. You could have raised the voice, you raised the voice. You went into the act, you went into the act. You conciliated. End of the matter. I subjected myself to the law. I did not run away. Now, once the things are over, she is supporting the department tacitly to initiate a proceeding which they cannot do so in law. That's the rule of law.
Yeah, Dubey, you'll have to explain. I think I have heard you.
But legally speaking, blood,
No, what is this letter?
that this is the review, blood, para 8 I have indicated, blood. That your lordship has seen. That again, that letter was sent to the ICC committee, blood.
Who is the ICC committee report?
Blood,
Letter.
this is the letter. Blood, they responded, my lord. That we have indicated in our affidavit. Yes. Blood, as an officer of the court, blood, there is, so far as the legal aspect is concerned, blood, that read with the affidavit of the circular, blood, even for initiating of a departmental proceeding, blood, there has to be a recommendation from the committee. Blood, that legal aspect is there. Blood.
Committee closed the issue.
Yes.
Nothing survives. No.
That is the only
The only problem, the
legal
only
thing.
issue is because the
Yes.
complainant wrote that letter saying
Yes.
that they delete or modify
Modify
that
that.
particular this language and then close the issue. That's also the language used.
Yes.
It says,
But from our understanding also, my lord,
Page 45.
it says
Therefore, to conclude,
it is requested to take necessary action to modify the statement for
That's-
closing the same,
for closing.
closing the case. That's all. What was the necessity to go for DB?
notification for which we cannot. You will have to.
The issue is whether the ICC has the power to review its order.
And even if they have, it will be to the extent of modifying for the purpose of closing the case.
No,
They-
that's why.
They cannot review a conciliation reached. They have no power of review. It's a very strict thing for a man. It's a very strict thing for a man. If a man does something and caught in the web, if he can't wiggle out through 10, then he's gone, 11.
Review
All
is the
proceedings
power
go.
of statute, my lord. If it doesn't confirm.
They don't have no power of review. But of course,
I'm not subject to what both my friends would, not if they, not so far as proceeding is in initiation of proceeding is concerned, not as the lame mandate, it should be with the recommendation of the ICC.
absolutely.
And Lord, if Lordship read that circular of ours, read with the act, Lord, the initiation may be, Lord, there would be difficulty on our part in justifying
He's
that.
fair.
But Lord, in the facts and circumstances of the case, Lord, we have taken this action, Lord. But since your Lordship is a 226 court, Lord, if Lord, both the parties agree, Lord, your Lordships can, Lord, say that this internal committee report should be read, that these are the observations to be deleted, Lord. That is one way of, Lord, mitigating that.
I am on the writ petition on the initiation of DP. I am not on the committee report. I have not even challenged that. It was the other person to challenge.
Because your Lordship has seen this letter, even in we of our own, Lord, at the threshold, we did not, Lord, act for going for the department proceeding. We first refer it to the same ICC, Lord, and Lordship has seen what their response is. Then, Lord, the authority decided, since, Lord, this has not been done, we should initiate. That is our para 8 report.
My friend has submitted in all fairness that they could not have initiated the proceeding. Of course, he has duty to defend, but he has submitted in all fairness that they could not have initiated proceeding. It's not supported by law. That's all. That's all. And my promotion aspects, everything has been stalled for that. The lady has nothing to do with it, Milo. The department and I.
Lord, had it been a case where the petitioner has come and challenged the
Absolutely.
committee
The respondent.
before your Lordships, the respondent,
Respondent.
perhaps that could be a
Case.
case where Lordship would have been pleased to open it up. He doesn't want that it should be open, Lord.
Why?
They want, by virtue of their letter, Lord, it should be open.
Not
And,
open.
Lord, we have opened it, Lord.
By virtue of the complainant's letter,
My Lord.
it's not said to open it.
Yes.
It's
Modify,
and
to close.
Issue.
To close.
That's
The
correct.
only problem is like we have all discussed. Whether the ICC has the power to review its own.
No, it's not there. No power is there.
There's no power.
There's no power to review.
Whenever it comes to ICC, I mean, I am on certain committees, ICC committees. We do not have that power. There's
That
no
power is not
statute
there.
is given.
Because
So, but then what happens? Sorry. But what happens, your Lordship, is that when supposing a woman during conciliation also feels, that I'm pressurized or something, then even then the ICC cannot force her.
No, that's
fair.
So she says, okay, I've done it. Now you modify. Now she is not on she's a very junior person. It's not that she's very senior and she has anything against the petitioner. It is just the fact that, okay, I've closed the matter. I've understood. Okay, for whatever reasons, I signed that conciliation agreement. Very good. Why has it gone up that it has been closed? Because I don't have evidence. I do have evidence.
That is fair enough. That's fair enough.
All right. Now, having said that, now if I have evidence and I have sufficient evidence, either now she's not on ICC should do it or the disciplinary authority. She wants that comment, that particular statement deleted. That's all she wants.
That's all.
She wants that. Whether he goes through that entire process again or he doesn't go, but who will do it? But having said that, your Lordship, now, as I said, already everybody knows about it. So many more people. So now she's more in the focus that, oh, you're lying. It's a lie. What you've done, the entire thing is a lie. So if that statement, if your Lordship, it's entirely up to your Lordships. If Lordships can come to something, give a direction that particular statement should be deleted, or it's absolutely, but that statement has to be deleted.
But I am not against what she's-
modified. It has to be modified or it has to be deleted. Something has to come to that. So that is what she's not on that. It has to be done to the disciplinary
No,
authority.
once
or
they're
the
admitting
ICC.
that should be closed, and I'm not objecting that it should be closed or not. It should be closed. What I'm on is that what she's not referring to is that, my colleague, that the DP is bad in law.
that he has already.
Then, so far as the other part,
DP is bad in law.
other part, Lordship may refer the matter to the authorities,
No, to who?
Whom?
the
Exactly.
ICC.
No.
In equitable jurisdiction, my lord may refer the matter to consider this part. That's all. Without the closing the settlement being touched.
Entire fresh proceeding will be there. Not only this part.
So they cannot be a fresh proceeding against me, my lord. The conciliation has ended. They cannot be hard one to somersault again against me.
But could it be a case, Lord? Lordship is holding that the DP could not have been initiated. What is aggrieved is so far as that observation, Lord. Lordship can, Lord, with the consent of both the parties, say that, Lord, this should be read as the Lord, that can perhaps.
To the extent that line be obliterated, omitted is okay. But to hold it against me, any sentence would not be okay perhaps in the fitness of things.
Had you filed a writ petition, if you had.
This is not her writ petition, Miller. I would have understood the writ petition by her.
आपने तो challenge कराना है ना.
But whatever, but however,
Lord, perhaps we have extended a bit.
See, I'm
Beyond.
thinking of something.
Yes, my lord.
So
So
that
that,
both
my
the
lord.
complainant and
Yes.
Absolutely.
petitioner
Absolutely.
need not come to court again.
yes,
Lordship.
yes,
So far as petitioner is concerned, this court is clear.
yes.
Clear.
As regards the DB.
Okay.
Is clear. But I'm thinking about the complainant.
Yes.
Why should she be subjected to another
Absolutely, Your
My
Lordship.
lord.
petition?
My lord.
So now, even for this court, how do I interfere?
Had she filed a writ petition or
No, no,
assuming she
that-
has raised a grievance,
That part.
and anyways, we leave it to that.
part,
That can be dropped.
My lord.
That observation can be dropped and no
My
more.
lord, your lordship's hands are not bound under 226, my lord.
No, I'm not on that. I'm not procedural restrictions on niceties. What I'm submitting is
My
that
lord, even your
Here we
lordship's
go.
observation will, my lord, perhaps
what I'm
Uh,
submitting is that
sort out the issues which are
let that
there.
observation be dropped without casting any aspiration against me. Let there be no add-on. Let there be a deletion. That's all.
Lordship,
That's what
just
you
as-
wanted?
Lordship, just as he is so worried about his own reputation.
No, I'm not
She is
worried.
also equally worried about
I'm not
her
even worried. I am a reputed man.
She is a reputed woman.
That's all. We are friends. Good together.
That's not how it works. Now it's become very publicized. That's our thing is we don't have any issue that it goes to the ICC or the departmental proceeding. We just want justice in the sense that my name is now aligned over there and everybody knows things I'm lying about it because they said that, it's explicitly written that there is no evidence, no nothing, but she had everything. And how many people is she going to explain? So I leave it up to your lordship to decide how we will delete or modify that particular ICC observation report. Contempt.
File for opinion for it. No? But I agree by because that remains. He's got proceeding. You are concerned. Is right one that again a proceeding is to be initiated for getting that. Then why you take this matter? That perhaps your lordship's observation, my lord, would help the cause of both the parties. Saying that your lordship says that what your lordship wrote, that the letter intent and purport of the letter was this, which they also agree, and could not have been initiated in the department.
To the extent of dropping that line is okay, but not against me a word any further. That he may not vouch for that.
No, I'm not saying anything against that.
I'm not a member of the ISTC. This court is not a member.
That's
of-
all.
I cannot make any observations against
Lordship.
anybody.
Yeah, that's
Only thing is that this particular it is the first para of the conclusion.
Yes.
not.
If that goes, everything is solved.
Yes.
Correct?
Yes,
If
Lordship may refer the matter to the authorities to reconsider in the light
They
to
don't
the
have-
extent.
they don't have the authority under the
Well,
act.
if that be so, my lord, we would also have jurisdiction to do some other things.
Exactly, that's what I wanted to fall from him, Miller. There is no jurisdiction. End of the matter.
That I'm admitting.
Whatever
that I'm
he's admitting,
admitting.
Miller. Whatever happened has happened. Let there be no heart burnings. End of the matter. Only my DP goes. Rest whatever they do. My DP goes. They can agitate their cause with the authorities. They can write letters for inaction. They may come. They may not come. But I am having a sympathy towards my colleague. All right. You may have felt it the other way around. Fair enough. If you can, in a way, in accordance with law, have that line removed. No issues with me. But don't cast aspirations on me. DP may go.
Heard this panic learning concept. Also heard Mr. R. Dubey. You're the standing counsel?
Yes,
Or
sir.
You're the standing counsel,
Airports Authority of India.
Airports Authority of India, for the respondents 1 to 6.
1 to 6.
1 to 6 NMS.
Dr. N. Guru.
Dr. N. Barrow, legal counsel for the response number 7. Stop. Para. The respondent number 7. You are serving us at that point of time.
Presently posted in count.
Anyway, let us not go into all these details. The respondent number 7. What is the complaint? Lodged a complaint on 29/1/2020 before the Regional Executive Director, Airports Authority of India, RSQ, NER, Guwahati, complaining of sexual harassment at workplace against the petitioner. Stop. The said complaint was made under the provisions of the sexual harassment of women at workplace within bracket prevention, prohibition and redressal close bracket Act of 2013 within bracket Act of 2013 in short. Stop. The said complaint was placed before the internal complaints committee. I respond number 6. Stop. During the proceedings of the ICC, there was a conciliation between the petitioner and the respondent number 7. And on the basis of such conciliation, the petitioner and the respondent number 7 issued a statement on 39/2020 stating that they have arrived in a conclusion today during the meeting, during the proceeding of the meeting to conciliate the matter, and that they were both forgetting all the past bitterness and shall maintain a good official relationship to each other, and that no situation may arise in future. Stop. It was further declared that no further follow-ups shall be made in the matter from their sides, from both their sides. Stop. Para. In terms of the statement made by the petitioner and the respondent number 7 on 39/2020, the complaint proceedings was closed by way of an inquiry report dated,
The summary proceeding is on 30th of September 2020, page 35.
no,
That moves into the report, my lord.
closing this.
That moves into report.
Is it 2/11/2020? On 2/11/2020. Stop. The conclusion of the inquiry report reads as under. 8, page 43. Stop. Accordingly, Sapala. On the basis of the said aforesaid conclusions, which the inquiry report was forwarded for acceptance. Stop. Para. However, respondent number 7, by a communication dated 25/2/2021, addressed to the General Manager within bracket HR, Airports Authority of India, Rajiv Gandhi Bhavan, Safdarjung Airport, New Delhi, Desh 3. Requested to take necessary action to modify the statement for closing the same, for closing the case. Stop. The relevant portion of the letter dated 25/2/2021 is also reproduced here in below. Page 45, B to B. Stop. On the basis of the communication dated 25/2/2021, the respondent authorities initiated departmental proceedings. Where is the departmental proceeding?
Annexure A, my lord. Lordship finds
Departmental
page
proceeding
22.
against the petitioner as per under regulation 29 of the AAI employees within bracket conduct, discipline and appeal, close bracket, regulations 2003. Stop. The being aggrieved with the initiation of departmental inquiry, I don't know what is it, initiated the departmental inquiry. No? by memorandum dated 25th October 2022 under regulation so and so, huh? Stop. The petitioner being aggrieved with the initiation of the departmental inquiry is before this court by way of the present writ petition. Stop. Para. The learned counsel for the petitioner submits that the Act of 2013 is a special act in respect to prevention of sexual harassment of women at workplace, and therefore submits that unless there is a recommendation made by the respondent number 6, the initiation of departmental proceeding by the respondent authorities is not tenable, for which the entire proceedings needs to be set aside and quashed. Stop. The learned counsel for petitioner has drawn the attention of this court to section 10 of the Act of 2013, particularly section 10 within bracket 4, which provides that where a settlement is arrived under subsection within bracket 1, under subsection within bracket 1, no further inquiry shall be conducted by the internal committee or the local committee, as the case may be. He submits that as the parties, as the petitioner and the respondent number 7 has come to a conciliation and has issued a statement to that effect, and the ICC accordingly has closed the matter, comma, the initiation of the departmental proceeding against the petitioner should be set aside and quashed. Stop. Para. No, so don't say para. Learned counsel for the petitioner has also drawn the attention of this court to the additional affidavit filed by the petitioner, particularly to annexure to the is the order or what?
This is a circular of
There is
theirs.
a circular dated November 5, 2014, issued by the executive director within bracket HR, Airports Authority of India, whereby the rules oblique acts, no, whereby the AAI policy circulated on prevention and redressal of grievances relating to sexual harassment at workplace was superseded, and the Act of 2013 was adopted. Stop. Mr. R. Dubey, Learned Counsel for the Learned Standing Council AAI, fairly submits that no recommendation was made by the ICC, and therefore the departmental proceeding against the authority, against the petitioner may not be tenable in law. Stop. He, however, submits that after the communication dated 25 to 2021 was received from the respondent number 7, the authorities have forwarded the matter to the ICC, correct?
Well.
And the ICC, by communication dated 4/5/2022, replied back that as the complaint was disposed of on mutual consent between the parties, there was no need to go for further proceedings, as the matter was closed based on mutual consent / joint statement submitted to the committee. Stop. Para. Any more? Nothing.
But this was an independent exercise.
He however submits that the initiation of departmental proceeding against the petitioner was an independent exercise by the respondent authorities. Stop. Para. Dr. N. Barwa, learned counsel appearing for the respondent number 7, also fairly submits that the respondent number 7 had indeed written the letter dated 25/2/2021 to modify the conclusion part of the ICC report, wherein it was stated that where is that report? Wherein it was stated that due to lack of evidence / proof / witness, no conclusion could be made regarding the complaint dated 24/1/2020. Stop. She submits that the petitioner had all relevant evidence, had all the evidences, and had submitted the same before the authorities. And therefore, the observation made in the conclusions has affected the moral of the petitioner, by way of which her integrity is questioned as on today. Stop.
And reputation.
Her integrity and reputation is questioned.
It should be respondent, not petitioner.
Oh, okay.
I haven't-
Respond number 7. Huh? Stop. She therefore submits that the petitioner only wants to maintain her reputation and integrity by having the conclusion part of the inquiry report modified. Stop. Para. After hearing the learned counsel for the parties, comma, and on consideration of the materials available on record, what this court has noticed that the petitioner and the respondent number 7 has issued a joint statement on 30/9/2020, whereby it was stated that they have arrived to a conclusion today, during the proceeding of the meeting to conciliate the matter, and that they were both forgetting all the past bitterness and shall maintain a good official relationship to each other Is there any guidelines, any orders that you cannot be transferred out at the second of your career?
Petitioner joined in Morikawa district on 18/7/2023. In guidelines says, my lord. I when I
Where did you join? 18/7/2000? Hmm.
So if they were posted as executive engineer, Morikawa division against the existing vacancy. It was dated 18/7/2023. Guidelines says, my lord. The person came up to transfer before my 3 years of my lord.
Where is that? Where is that guideline?
Guideline I have annexed is 30 months onwards. Many guidelines. They will be last guideline. Page 13. Page 39. Page 13. The state government have issued circulars from time to time outlining the rules of transfer and listing of government. This circular encourages people to transfer to officers that will normally be transferred normally as a public of 3 years. Of service.
You were transferred in Morrigan in 20.
18/7/2023, I was transferred to Morrigan. And by the imperial order dated 23/2024, page 30, I have been again transferred in violation of the law.
Yes.
I have left 65 days from today.
Now it appears, I don't know, but from the office memorandum that I've gone through now, with the latest office memorandum, 6 August 2023, it provides that when a person who has not completed 2 years, prior approval of the chief minister is required.
Says that officer cannot be allowed to serve in his home district at the time of elections. So at paragraph number 16 of the petition, Your Lordship, at page number 10, petitioner has made a categorical statement at paragraph number 16 at page number 10. That the petitioner begs to say that it is reiterated the petitioner will be 64 days left for his retirement on 2024. And at this stage, if the transfer order dated 23/2024 is allowed to be effective, then serious prejudice will be caused to the petitioner, as he will be out of home district before the fact from 1994 to 2024. Perhaps, Your Lordship, because during the elections, there is a specific bar from officers from serving in their home district, Your Lordship, perhaps that is why he has been transferred. Because this matter has come out as an unlisted matter, I do not have the instruction. But even otherwise, Your Lordship, since this post is a transferable post, as per the recent judgment of the Honorable Apex Court, is the office memorandum would not give him a vested right, Your Lordship, to claim that he cannot be transferred. The office memorandum, in fact, guides the department and how the transfer is to be effective. So he will
No, at least, did you follow that?
because this matter has come up suddenly. I do not know if he has been transferred because if it has been transferred because of the guidelines of the election commission, then perhaps that will override this office memorandum. Since it's serving in the home district.
That is a different issue.
Yes.
And if that if it is not done because of the election commission's, then the office memorandum will have to be followed. Whether you have taken the permission of the chief minister, prior approval. So that one. You want to take instructions? When do you want?
Because it's not an interstate transfer, he has been transferred in case of person who has been provisional. and nobody else has been transferred in his place. So he can remain where he is.
Heard Mr. PG Saikiel and the counsel for the petitioner. Stop. The petitioner by a notification dated 18/7/2023 was posted as EE within bracket PHE, Murigaon Division, against existing vacancy with effect from the date of taking over charge and until further orders. Stop. By another order dated, by another notification dated 22/2/2004 to 2024, the petitioner was transferred and posted as EE within bracket PHE in the office of the ACE within bracket PHE, North Assam Zone, Tezpur, from the Murigaon Division. Stop. Thereafter, by another notification dated 22/3/2004 or 2024, the earlier notification dated 22/2/2024 was cancelled and the petitioner was transferred as and posted as EE within bracket PHE in the office of the EE within bracket PHE Bogagat Division. Stop. Being aggrieved with the notification dated 23/2/2024, petitioners before this court. Stop. Para. It is the case of the petitioner that he is in the back end of his career and having 64 days remaining for his supination, and therefore transferring him out of his hometown would have serious repercussions. Stop. The further case of the petitioner is that the respondents have issued several office memoranda, particularly the office memorandum dated 6 August 2023, which provides that when an officer, it's written 23 here. Oh, 2013, which provides that the approval of the chief minister is required for transfer of any officer who has not completed 2 years in a particular place of posting. Stop. Para. Mr. KB Pathak, Leonard, Standing Counsel, PWD, no, PHA. Press for some time to enable him to receive instructions. Stop. Press allowed. List down. We'll have it on 5th March 2024. Till the next reasonable date. The notification dated 23/2/2024, by which the petitioner has been transferred and posted as EE within bracket PHE in the office of the EE within bracket PHE Bogagat division shall remain suspended. I'm not issuing notice. Because there may be something important.
23 of Delhi List, admission.
Have you filed your reply affidavit? Hmm. When did you file your reply? Your response number? Assam State, its controls. Respond to. Your counter is there. Your counter is there, but your reply is not on record. When did you file it? Give me the date. Okay. Mr. A. Bhattacharya and the counsel for the petitioner submits that he has filed an affidavit in reply to the counter affidavit filed by the respondent number 2. Stop. Registry to verify and place the same on record. And list the matter again after 1 week, 2 weeks, after 2 weeks. By reflecting the name of the standing council, Assam State AIDS Control Society in the cost list. Let's see. March is difficult.
24.
Your lordship, because she had applied in a belated manner, your lordship. This was the case where the minor was there. He was a minor, your lordship. But after attaining majority also, he waited for 2 years or more thereafter also for applying again. This is why, your lordship, I have said this is
Anyway, today we don't have time. We'll fix a date. Heard Mr. A.K. Barwal and the counsel for the petitioner, as well as Mr. C.S. Hazarika, learned government advocate, and Mr. P. Andik, learned counsel appearing on behalf of Mr. K. Kunwar, learned standing counsel PNRD for respondents 4 and 5. You want a date or list after 2 weeks? Okay, list on 18th March.
25.
Extension of 1 year. That period for which you want extension logic, that period is already over logic. So what remain in this case logic? He wants.
In this case, they have filed the extension in respect to the petitioner was not granted before.
But anyway, you have stated.
Fraudulent LTC has been
pending against.
Hmm.
No case, no department. On merit, he may have that submission, but not his prayer portion.
No, prayer portion says
Because he is by curtailing his rank, he has been shown as constable.
for extension of 6 tier.
He is working as the head constable. Lordship, kindly see page number 27 of the rate petition. His extension was not granted, but his extension period, Lordship, may kindly come to page 27. The rate petition.
Yes.
The last in the
Hmm.
table, Lordship.
Hmm.
I now have period proposal for issue of NOC for extension of 6 deputation tenure from 5 to 23 to 4 to 24. So now, Lordship, how can he seek for extension for that period, Lordship, which is already over? And more so, he had returned back to his original department of SSB in the month of July 20. Extension has to be continuous process, and the period is not. After it is indicated that easy SSB has constructed LLC in respect of the movement personnel of SSB presently on the PCS.
Anyway, you have completed the term. Today is what? You wanted up to 4 to. You have any course of action to proceed further? Can we proceed further with this writ petition? Your extension period is over. No, when did he join back to his?
It's a 51 running phase. One of my he is on deputation pure civil aviation. Actually, he is from Sasastra Simhabal. So, Lordship, where is Sasastra Simhabal? Lordship, can kindly come to page number 50. That continuous page paragraph. Yes, Lordship. 51 of my affidavit filed by SMT. Paragraph
1 minute.
15.
SSB is respondent number.
Number 5. Continuous page 15 is number 51.
Something is wrong. Which annexure?
Oh, I have stated.
Para? So you've gone back. You've gone back to SSP. So the further continuation of your deputation in here does not arise. Have you gone through this para 15? Have you filed reply? Let us see your reply.
Submission. Page 106.
Yes.
CD paragraph number 5 of my cover is considerable.
Para? That we have seen. So you're praying for deputation from 5 to 2023 to 4 to 2024, isn't it? See, you have been repatriated from PCS on 3 to 2023 to join SSP, and you joined on 27/3/2023. Okay. Your prayer for extension of your deputation period is from 5 to 2023 to 4 to 2024. By that time, you have already gone and joined your SSP. What more survives? So, what is there in your prayer? What is there in your prayer portion? What is there in your prayer portion? What is your prayer? Why? Okay, on request made by your good name. Learned Counsel for Petitioner. List on 5th March. MS B. Sharma, Learned CJC appears for the respondents.
26 and 27.
I have not received my extra copy.
You furnish copy.
Many times, but it is not.
Serve now. You have some extra copy? Okay. 11 many cases are fixed, 13 will have. You want to file your affidavit or not? Heard Mr. A.R. Boyan, counsel for the petitioner in WBC 2546 of 2023. And Mr. H. Das, learned counsel for the petitioner in WBC number 2395 of 2023. Stuff. Mr. J. Hendrick, learned standing counsel, Revenue Department. Prays for how much time? 3 weeks time to file counter in WBC number 2546 of 2023. Praise a lot. List after 3 weeks. 20 March.
28.
Yeah, who appears for the respondents? Who are the respondents? Education.
only the standing council education is reflected, that's why maybe others are not appearing or they are not getting the. That's the thing. By an order of the following board, at the beginning, it's clear that this matter would pertain to 3 months, and so this matter has come before your report. The order which can, by way of question of
Okay, let the names be reflected. Heard Mr. H. Buragohan, Learning Counsel for the petition. Registry is directed to reflect the name of the standing council. Known as Standing Council, State Level Recruitment Commission. In the cost list. You want a date and list the matter again on 14th March. And also the Standing Council Seba, and list the matter on 14th March.
30.
Okay, MS as thus Learned Counsel for petitioner. Prays for 2 weeks time to file reply to the counter filed by the 2, 3, 4, and 5. Praise allowed, list after 2 weeks. MS K. Fukan Leonard CGC appears for the response number 1. Later file your affidavit. Yeah, record.
33. 33.
Who appears for the respondents? Time was given for you to file your affidavit. You filed. When did you file? 11 for the response number. Okay, none appears for the petitioner. Mr. C.S. Hazarika, Learned Government Advocate, submits that the response number 4 has filed affidavit on 11/1/2024. Registered to verify and place the same on record and list the matter after 2 weeks.
35.
'Lordship, they have filed their reply today. We have received the copy today. Therefore, my lord, the matter may be fixed on some other date, Lord. After 2 weeks.
Okay, Mr. B.B. Sharma, Learned Counsel for the petitioner, submits that they have filed affidavit in reply to the counter affidavit filed by.
He's filed petition.
You have filed, isn't it?
The counter affidavit filed by car against my file.
Filed by the respondents 3 and 4, registered to verify and place the same on it. And list up to 2 weeks.
Yeah.
And list the matter on
19th
19th.
March.
Deeply obliged.
36.
This is not a respondent 7 file affidavit.
Yes.
Respondent 7 file. Title department is respondent number 1.
Lordship, we have not received a copy of the petition.
Who's the respond number 1? MS in the Learned Counsel for petition
RM
shall
does it.
furnish a copy of the writ petition to Mr.
C. Sharma, Lord.
C. Sharma, Learned Standing Counsel, Social Justice.
Lordship, I am appearing on behalf of Mr. R.M. Das. He is the standing counsel.
Shall furnish a copy to Mr. R.M. Das, Learned Standing Counsel, Social Justice and Empowerment Department within the course of the day. List the matter after 2 weeks.
On for the respondent number 7.
Mr. J.K. Barajuli, Learned Government Advocate, appears for respondent 7.
38.
What is it? Counter. Counter not filed. Counter has not been filed. Who appears? Yes.
Lordship, the state of Assam received the paragraph comment, Your Lordship. Time permitting.
Chaudhary?
Lordship will give me 2 weeks time, Lordship.
Okay, heard Mr. P. Jagavati, Learned Counsel for the petitioner. Mr. R.K.D. Chaudhary, Learned Deputy Solicitor General of India, and Mr. C.S. Hazarika, Learned Government Advocate, are both allowed 2 weeks time to file the respective counter affidavits. List after 2 weeks. List on 20 March.
39.
Yes.
My lord, we have not received any instruction. Otherwise, my lord, there is a representation filed by the petitioner.
You try to receive instructions.
But he is agreeing that if the representation is disposed of, my lord.
The government has approved me for the post of LDA.
But he has not been given the because initially he was serving in a different post, my lord. Subsequently, he has been appointed in the post of LDA, my lord. So the past service benefit has not been provided to him, my lord. And regarding that, he has filed one representation, my lord.
No, you are against the speaking order, isn't it?
Yes. Against the speaking order, he has filed one representation, my lord.
Where's the speaking order?
39, 39. Next item. The equal portion. The last paragraph. Item revision before government has approved me for the post of LDA and
Okay, heard, mister. Your good name. I, Hussein, Learned Counsel for the petitioner, also heard Mr. D.B. Bora, Learned Standing Counsel, Health Department. Stop. By this writ petition, petition is challenging the speaking order dated 1/9/2023, is it? 1/9/2023 issued by the Director of Health Services, Assam, by which it has been held that the petitioner will not be entitled to claim previous in-service financial benefits as well as claim for seniority for promotion to the next higher cadre of post within bracket IE from LDA oblique junior assistant to senior assistant from the initial date of joining as basic health worker within bracket PHW stop not stop, and the seniority will be counted only from the date of joining as LDA oblique junior assistant. Stop. Learned counsel for the petitioner submits that the petitioner has filed a representation before the Director of Health Services, Assam, oblique respondent number 7, dated on 2010-2023. Stop. He submits that this petition may be disposed of by directing the respondent number 2 to consider a representation dated 2010-2023. Stop. Para. Mr. D.B. Bora, the Standing Council Health Department has no objections. Stop. Para. Accordingly, this writ petition is disposed of, directing the Director of Health Services, Assam, oblique respondent number 2, to consider and dispose of the representation dated 2010-2023 made by the petitioner within a period of
4 weeks.
1 month from the day and in accordance with law. No, the representation so by a speaking order and in accordance with law within a period of 1 month from the date of receipt of a copy of the order of this court. With the above observations and directions, writ petition is disposed of.
My lord, in item number 33, I am for the petitioner. I was on leave in before the division bench. My appearance may be recorded, my lord. 33, my lord, the government has filed affidavit and it has been directed to verify
Okay,
that.
33, just heard DB Bora and then other orders continue.
Obliged.
Yes. I have a meeting at 4:30. All right.